Good afternoon. This is the meeting of the Blue Ribbon Commission for the future of the California Bar. I'd like to welcome our members as well as members of the public. This is our sixth meeting now, it's hard to believe. And for the benefit of the public, I'm going to read, as I have in the past, the charter, which is as follows. The Blue Ribbon Commission is charged with developing recommendations concerning whether and what changes to make to the California bar exam, and whether to adopt alternative or additional testing or tools to ensure minimum competence to practice law. Both today and tomorrow, we will continue with the format that we've adopted with subcommittees. Today discussing a non-exam alternative, and tomorrow discussing an exam format for the future of the bar. I'd also like to take roll, and then we'll start with the public comment. Ms. Wong?
Sure. Susan Bakshian.
Present.
Jackie Gardina.
Here.
James Henderson.
I'm here.
Esther Lynn. Judge Glenn Bracer.
Here.
Kristen Rossi. Mylene Spencer.
Here.
Amy Williams.
Present.
We have a quorum, Justice.
Thank you very much. We'll begin with the call for public comments. As noted on the agenda, the public comment portion will be limited. Members of the public wishing to comment were encouraged to submit any written comments prior to the meeting today, and the commission has received public comments. There were 4 comments from 3 individuals, and we thank each of you for submitting those. I will ask Ms. Wong to call members of the public in the order that they appear, if there are any, and public comments will be limited to 2 minutes. To facilitate hearing as many as there are, we ask that you not repeat any comments of prior speakers, and to allow the commission the opportunity to continue with the business portion of the agenda, we'll limit it to 15 minutes. In terms of the logistics, if you're participating by Zoom, you should have a function that allows you to raise your hand, which is a hand icon that should appear at the bottom of your screen. If you are participating by phone, you should press the star key and then followed by the number 9. And I'll ask Ms. Wong to call the public comments at this time.
At this moment, we have one public comments from Mr. Julian Sarkar.
Thank you.
Thank you, Ms. Wong. Good afternoon. My name is Julian Sarkar. I represent attorney applicants against the State Bar and NCB's unlawful practices. I want to thank you all for the generous time and talent you've dedicated towards this Blue Ribbon Commission. And some of you have already done this work in the past, for example, on the California Attorney Practice Analysis Working Group. I'm here today to urge you to maintain control over this commission's final report to the Supreme Court. It's highly unlikely that the Supreme Court reviewed the individual recordings of the CAPA Working Group meetings themselves, and just as unlikely that they will review recordings of meetings such as this one. The CAPA Working Group included some very impressive members who showed dedication towards improving fairness and equity in the legal profession. But just like on this commission, the CAPA Working Group also seated a lobbyist from the NCBE, a private Wisconsin corporation run by homogenous attorneys who have never even taken their own bar exam. I highly doubt that those members of the CAPA Working Group that I was referring to decided to use such a corporation's so-called research on exam materials that those members were not allowed to see. It is more likely that the NCBE's lobbyist and the State Bar executives and employees who pay themselves with the profits from the California bar exam decided that the CAPA Working Group's final report should protect their business interests, regardless of its truthfulness or accuracy in reporting those members' work. Similarly here, those same State Bar executives and employees initially proposed a Blue Ribbon Commission charter that would have given you only 2 options: keep the current exam or adopt the NCB's uniform bar exam. At the very first commission meeting, several members stated that they weren't certain the bar exam was necessary. Those insightful comments have been made by others over the past century. But in the same way that the time that you've generously donated to this commission competes with your other obligations, previous critics of the NCBE also didn't stand a chance against the monopoly entity's capable lobbyists. Take it from the NCBE's own top psychometrician, Dr. Susan Case. She wrote in the NCBE's quarterly publication, The Bar Examiner, that, quote, complaining about the relevance of the bar exam distracts from the examinee's job, which is to pass the exam. Parens. Besides, current examinees who suggest eliminating the bar exam entirely would not succeed in doing so within a window of time that is relevant to them anyway. Parens. Again, I appreciate the time and work you've invested towards the fairness and equity in the legal profession, and I urge you to prevent the NCBE and the State Bar's executives and employees from rendering this work ineffective by misrepresenting it in the Commission's final report to our Supreme Court and retaining creative control over how your work is represented in that report. Thank you very much.
Thank you, Mr. Sarkar. At this moment, Judge, we don't have any other public comments. So,
Okay, thank you. And thank you for that public comment. We'll go ahead and move on to the business portion of the agenda. The first item on the agenda is a discussion of the experiential education that's currently offered by California law schools, and that will allow us to discuss the applicability to a non-exam pathway. The presenters for this portion of the agenda are members, Dean Jackie Gardina of Santa Barbara and Ventura College of Law. We also have Andrea Funk, my understanding is colleague, who is the faculty director of the hybrid and online program. We also have Commission member Susan Bangshian, director of bar exam programs for Loyola Law School, as well as Peter Beer, who is a professor and director of administration with Oak Brook College of Law. And also we have Commission member Mylyn Spencer, Associate Clinical Professor at UC Hastings. So welcome to each of you and thank you for joining us here today.
If did Jackie and Andrea want to start? I have them you first on the
Okay, wonderful. And there we go, just perfect. So my name is Jackie Gardina. I am the Dean of the Santa Barbara and Ventura Colleges of Law, and Andrea Funk is the Associate Dean of our hybrid and online learning programs. Both of us come from an ABA background and moved to the Cal accredited law schools. Me about 6 years ago, and then Andrea joined me about 4 years ago. So we do have a foot in both worlds. So what we're going to do in this presentation is twofold. One, to introduce you to our students and our school and the experiential work that we do. And the second is to really focus in on the hybrid JD program and how we decided to do experiential learning in that context. I'm going to take care of the first part, and then I'm going to pass it on to Andrea to take care of the second part. So next slide, please. So let me just introduce you to our students. We have a campus in Ventura County, a campus in Santa Barbara County, and then we have our hybrid JD, which actually kind of attract students from throughout California. The Ventura and Santa Barbara are traditional campus programs, and the students come in the evening 3 times a week, 40 weeks a year. The hybrid program is 70% online, and then 30% of the time, which is once a month for an intensive residency, they come to campus. The average age of our student across the entire population is about 37. Most of them are working adults with families. Many of them have professional careers, either within the legal profession now or other professions, but they're seeking to kind of connect with a long delayed dream. So I want to talk next about the relevant bar provisions. I'm going to talk about 2. So The first one is the one that you might be familiar with. We're here to talk about professional skills. And under the State Bar of California's accredited rules, which just came into effect in January, this rule existed beforehand, but it also was carried over into the new rules. We're required to have them complete a minimum of 6 semester units of practical skills work. But we also are required in our curriculum to give them the opportunity to complete at least 15 units of practical skills work. So it's 6 required, but an opportunity for 15 built directly into the curriculum. Next slide. I want to juxtapose that with the other requirement in the State Bar rules, and that is that we must present the students with every subject that's tested on the California bar examination, of course, including a course in professional responsibility. And so let's talk about that in relation to the bar exam as it currently exists. So next slide, please. So you can see based on this slide that a vast majority of our curriculum and our students' attention are taken up by bar exam tested subjects. Unlike many ABA law schools, most of our bar tested subjects actually span the entire year. So many of these are actually 6-unit courses, not 3-unit courses. And so that takes up a great deal of room in a part-time program for working adults. Next slide, please. I want to talk a bit about our practice-based curriculum, but I did want to mention 2 things about the bar exam courses that I forgot to mention when the slide was up, and that is not only does it drive the curriculum in many ways, but it also drives student attention. Students are very focused on what do I need to know to pass the bar exam, and unfortunately less focused on what do I need to know, understand, and be able to do to be a skilled, competent, and ethical attorney. And as you know from the demographics that we serve, our students, just on a percentage wise, tend to struggle a little bit more with standardized test taking in the bar exam than some other students. Nonetheless, in our traditional on-ground program, we provide practical skills opportunities. On the required side, we have legal research and legal writing, scaffolded courses. We also require a pro bono internship that every student must complete. We also offer a series of elective courses that are skill-based, that are offered mediation, negotiation, trial practice, contract drafting, etc. And those are offered to students each year, and it's not an exhaustive list, it's an example list. So the students are given the opportunity to both engage in more in-depth practical skills through coursework, as well as through internships, and also the required ones in terms of writing. So next slide, please. But now I want to talk about how we wanted to do it differently. So when I started at colleges of law, we made the decision that we were going to create a hybrid JD to increase access. But I didn't want to just take our on-campus JD and move it into an online platform. I actually wanted to use it to create the next generation JD. What should that look like? A JD that wasn't tied to the legacy of a traditional program. So what I did was I invited thought leaders from across the country, some of whom you've heard from in presentations here. And I said, create the next generation JD. And I broke them up into groups and I had them kind of come up with what they thought the next generation JD would look like. I put that putting the doctor back in Juris Doctor because it came from a conversation with one of those groups. They asked a very specific question. Can we build a JD without worrying about the bar exam? I was unable to be that free with them because I was going to have to create a JD that actually took the bar exam into account and took in all of the requirements regarding bar tested subjects into account. So I said no. They had to think about this through the lens of the bar exam, because what they wanted to do was actually create a very practice-oriented JD that connected both practice and theory together in a rotational context. And they came up with an incredibly imaginative and wonderful JD program that unfortunately we were unable to actually create, in part because of the bar exam and the curricular requirements around that. Nonetheless, when we created the hybrid JD, we really did work to weave in practical skills in a way that was different than in our traditional campus program, with the idea that if we found that it worked, we would then move it over to the traditional campus program so that all students had access to the same skill-based learning. I had the great fortune of hiring Dean Funk to join me, and she really took that idea on paper and manifested it into the program. And so I want to pass it to Andrea to go on with what we've done in the hybrid program.
Thank you so much, Dean Gardina. This really has been the professional challenge of a lifetime, and I feel so grateful to have had this opportunity. So I'm going to get started talking about experiential learning in the hybrid JD program. And as Dean Gardina said, when everyone from around the country got together and started thinking about, gosh, if we could really start from ground zero and work our way up, what would we do? How would we make this education come to life? How would we bring the, words off the page, so to speak? So given that blueprint, we had to figure out how to marry the traditional school offerings that we were required to offer, but deliver it differently in a way that infused experiential learning at every step. So first, before going on to that, I want to tell you a little bit about our students. The demographics in the HJD program is really unique. Our mean age in the program is 40. Some years we're in our 4th year. Some years it's been 42, but overall it's 40 years, 60% female. And I took out 2 stats that really are noteworthy for race and ethnicity. 24% Latino or Latinx and 13.7% Black or African American. And I have to say, one of the reasons that I know I came to the school and why Dean Gardina's leadership has been so compelling to me in the mission of the school is to provide access to an affordable and a quality education throughout the state of California. And I think, and again, these are just 2 numbers. By the time you factor in other ethnicities, we are an incredibly diverse group. All right, so now let me show you a little bit about the specifics of the HJD program. We have 84 units. And as you can see, 57 units really are the bulk. They go to meet the requirements of the rules in the state bar. 18 courses are doctrinal and 1 is bar studies. So the bulk of our curriculum are things that are necessary. But how do we infuse experiential learning and practical skills everywhere else we can? And that was really our mission. So we have 8 units of a foundational semester, and this is really interesting. From the Hack the JD, the groups decided, gosh, wouldn't it be nice if before students started their doctrinal courses, everyone became situated in the law. They were all grounded. They all were brought to the same space. And so we have 3 courses in this foundational semester before standard doctrinal courses even begin. This is legal research, legal writing, and a course called Legal Fundamentals. You can think of legal fundamentals as a law school version of civics, making sure that people know, what is the federal and the state system? What's the hierarchy, the weight of authority? The professor teaches things like filibusters, which was quite relevant recently. We infuse issues of diversity, equity, and inclusion, and had the students read Just Mercy. So this is an opportunity to really ground students so that everyone is in a level playing field. We also have 5 lawyering skills units that are required, and I'm going to talk very specifically about that in a moment. We have a unit of a pro bono internship, 3 units of a capstone course, which I'm also going to describe in depth. And then we only have 10 units of electives left, which many students will use additional lawyering skills units to comply with because they're so interesting and helpful to our students. So this is an overview of the program. All right, now before I start talking about what we have done, I just want to, ask the question, what is experiential learning? People hear that phrase and have different definitions. I am using kind of a very traditional definition of it's learning by doing. It's learning by using the material that you are studying. It's learning by observing, by experiencing, right? It's very active and not passive. All right, so we have tried to infuse skills in literally every aspect of this program. And as Dean Gardina said, and I think it's really important to note, when I talk to people about hybrid programs, I say, well, what do you mean by that? What's your version of hybrid? What does that look like? For our version, we built everything from scratch. We didn't just take things from, as Dean Gardina said, we just didn't take them from the ground program and put them online. We built everything intentionally. So our focus in the HJD is to make sure that the material that the students are using throughout the program, that they're learning as much as possible, not just by a passive studying of the material, but an active use of the material. And we do that each course, each semester, each year, and also at the end of the program. So let's go through each course. So our program is 70% asynchronous and 30% on-site. So we have an online and an on-site component. Now, each doctrinal course was developed to cover, and again, like I said, this isn't just taking something and delivering it online like I know many people during the pandemic did, right? They just created a synchronous class and they spoke to their students online, and that was great. That wasn't what we had created. We created an opportunity for students to study like a flipped classroom, to study ahead of time and then to actually do work. So each doctrinal course was developed to cover 3 different items. 1, we had to make sure we addressed traditional law school cases, statutes, doctrine, theory, and policy. That was a must. We couldn't leave that out. We also developed the course to include California bar coverage. And by that, I mean all students and professors have access to Barbary throughout the program. And so we wanted to make sure that the coverage was such that in addition to the traditional, that bar coverage was front and center in the curriculum. And then 3rd, we married in this trilogy the practical skills. So how did we do that? Well, in each course, just like you would in a brick and mortar or traditional law school program, students would have to prepare 6 to 9 hours before they went to class. Here, they still have to prepare 6 to 9 hours. They have to view their professor's video to introduce the week, read the cases, do any kind of bar review information. They have to do all of that. But then in lieu of going to class, they have to produce 3 hours of work. And that could be testing their knowledge, but primarily it's skills, using that information. So for example, they could have a hypothetical client problem and they would have to use the material from the week, let's say it was torts and a battery issue, to solve the client's problem. And this tests that they know the material and in fact can use it as well. And the second part of that is that students receive individual and/or global feedback on each weekly assignment. So if they have 3 weekly assignments or 3 courses, they have 3 sets of weekly assignments that have to be turned in. This happens every week throughout the semester. Then twice a semester, they meet with their professors and a 12-hour on-site residency where they go over the material. So after about 4 to 6 weeks of this weekly asynchronous learning, they come together for an active problem-solving session to see, 1, do the students understand this material, and 2, how do they use it? They get together in law firm groups, they have practice problems. It's very active and very vibrant. And I will say, one of the, especially in the first and the second year, we are able to bring together several different subjects so that students can see how the law is interrelated. So for example, in the spring semester, where students have torts, contracts, and crim law, the professors will each have their own time with students on a Saturday, 2 or 3 hours each. But then on the Sunday, the 3 professors come together. They have one big fact pattern, one client, and out of that fact pattern, all 3 issues arise: a torts issue, a contracts issue, and a criminal law issue. And the beauty of that is, as we all know, right? Clients don't walk into your office and say, I have a tort. So let's just talk about that. Instead, clients walk into your office and start spewing these facts, and you have to decipher what is going on here. So this gives the students the ability to weed through the facts and figure out, how does the law apply? All right, so that's what we do each week in each course. Now let me turn to each semester. Another one of our monthly residencies, and I have to say this is really a highlight, is a lawyering skills weekend. And the idea for this came directly out of Hack the JD. And what we decided was there will be 5 required units before students graduate that they must take: 2 in practical skills, 1 in litigation, 1 in transactional, and 1 in professional development and leadership. Now they can take more. There's 3 to 5 other semesters that they will have the option to take these courses and receive a unit, but they must at a minimum do this. They're offered we have 3 semesters a year. And so, and there are usually 3 to 6 different tracks that are available with each semester. So what's important about this is that it really addresses that critique that graduates need more skills. As we all know, law firms really aren't training new graduates like they used to, and clients aren't paying for training of new graduates like they used to. In fact, from an employee standpoint, or employer standpoint, they might think, great, that is great that you got an A in wills and trusts, which by the way, we don't do here, but can you draft a complaint? Have you ever heard of a local rule? So this is really to focus on getting students familiar with what it would be like to practice law out there in the world. To give you an example of a practical skill, that it would be something that every lawyer really should be able to do. Some of the weekend offerings that we have given are an oral advocacy weekend, a weekend on mediation, research for practice as a junior associate, Logic for Lawyers we're offering in just a couple of weeks. Public speaking for lawyers. So just a few examples of things that are just very practical skills. Litigation skills. We have a pretrial lit overview so that if they don't take our full pretrial lit elective, they can at least see what the life of a piece of litigation is before trial. California motion practice. Many of our students, because we're a Cal accredited school, are going to be here in California practicing in California courts. And so we have a specific weekend on California motion practice, a weekend on summary judgment in both state and federal court. So again, very, very practical. Transactional skills. I think often in law schools, the curriculum focuses, it's very litigation heavy, but as we all know, litigation and transactional go hand in hand. You need to understand how to do something, how to draft a contract or an agreement well, so that it doesn't go to litigation, and vice versa, to understand from the litigation standpoint how the transactional person could have gotten off base. So for transactional skills, negotiation, how to draft basic contract terms and provisions, settlement agreements, and basic transactional skills overview. And then for professional development and leadership, a few of our sessions have been law practice management, how to set up a small or solo law firm, professional responsibility issues, and we've had a number of those in online marketing. And then we've married a few sessions on substantive areas with skills. Criminal law, what is it like to be a public defender and a district attorney? What are the types of skills that are relevant for each? International law, what are the skills that go in the global marketplace that you need to be aware of? So this is just, and students love these weekends because it brings the law to life to them. And they leave with a sense of what it is like to be a real lawyer after spending 12 hours on the weekend with a professional in these areas. All right. Each year, we have a writing portfolio project in the first year, second year, and third year. We've had a number of different offerings. What we're trying to do here is to embed writing into a doctrinal course so that students can see in this area of law, what are the types of things that I could do with it? How would I use this? So for example, yes, students learn in their first foundational semester legal writing course how to write an office memo, but then in torts, once they have some substantive knowledge, they now do a more sophisticated office memo. In contracts, they learn how to do key essential contract provisions. In Civ Pro, how to do pleadings like a complaint and an answer. Professional responsibility, write an opinion letter on an ethics issue. Community property, a client advice letter on how to dispose of and distribute multiple client assets upon divorce or dissolution. And then wills and trusts, how to draft both a will and a trust. By doing this portfolio project each year in conjunction with a doctrinal course, it allows the students to, upon graduation, have a portfolio that they can then take out to an employer and say, these are the types of skills that I have. It actually elevates that idea of just having a writing sample that is either an office memo or an appellate brief, which everyone usually has. And then finally, at the end of the program, we have the capstone course. And the entire goal of this course is to go beyond doctrinal knowledge and provide a bridge to practice. It is a focus on problem solving to understand what the client's needs are and the demands, to confront decision-making issues and challenges, to manage workload and to work in teams. And what it does is it has a number of different, yes, it uses some of the law that they have learned over the course of their doctrinal curriculum, but for the most part, we crafted an employment law issue, which they're not familiar with, so that they can figure out what to do when they don't know what the law is. And some of the concepts that are in this course that I think are really important for new lawyers are, how to obtain a client. How do you go about getting a client? How do you market your law firm? The business of law practice. There's that business aspect of it that no one tells you about, how to run a law firm. Of course, the client interview and how to identify those legal issues, which they've been doing really in every residency and almost every course since the beginning. We talk again about implicit bias and how it's embedded in the legal system. How to form entities, how to give client business advice, and then alternative resolutions. Not everything is a lawsuit. How to go about doing things differently, and then sometimes even how to think about how to use your JD in a non-legal career if that's appropriate. Now, we would say our program's in its infancy. We have just graduated our first class in 2021. Half of them are taking the bar in February, and there's another half, big group, taking it in, big group, the total group is 13. So I do, the numbers are small, but we have half taking them in February and a big group taking it in July. And so we're gonna watch the effect of this class. And I tell you that because I want to leave you, before turning it back to Dean Gardina, I want to leave you with one anecdote. And again, I emphasize, I know I do assessment, the numbers are small, but, and it's only been one class. But what is interesting to me, and I have been watching this group since the beginning and making changes to the curriculum since the beginning. In this group, the people with the students with the highest GPA were not those who excelled in the capstone course. Those in the middle and slightly below the middle were those who did incredibly well and received the A's. The professor and I talked about this throughout the semester as I was monitoring their performance. And we spoke about the problem-solving skills of these students in the middle and slightly below, and their professional skills and how taken she was with them. And so I would say, in other words, the students who were best at taking the tests were not necessarily the best at performing the skills as a lawyer. And again, small context, very small, but it will be interesting to watch if that is a theme throughout over the years. And so with that snapshot of what we do in the HJD program, I am going to turn it back over to Dean Gardina.
Yeah, I appreciate that. Thank you, Dean Funk. I'll be brief. It's just the last slide is really the question that we started with, hack the JD, which is.
Let me get to that last slide.
Which is really an opportunity for this committee. This committee is not just thinking about what is a pathway to licensure, but it's really going to go backwards and ask the question, what should the law school experience look like? And imagine what it would look like. I was excited when CAPA said, we might reduce, or we're recommending a reduction in the number of topics, because that will free up so much more space in our curriculum to take these kinds of lawyering skills opportunities and expand them for our students. So I look forward to wherever we come out here and in the committee as a whole, because it's going to have an effect on the legal education that students are provided. So thank you for listening, and I look forward to hearing the other presentations.
Thank you so much. That was a fascinating presentation, and we'll be interested to see how these 13 students do, and also future classes as well. I would like to open it up to any questions now from the group or at the end, but if there are any now, please raise your hand. Amy?
Yes, thank you, Justice. I have a quick question for this program. I noticed that they had a line item of projects, written projects that the students will be working on first, second, and third year. it seemed that those projects were singular. How many of these written projects per class per year are actually being done?
This is a great question. So far, every class has, and again, we are still small and building, but so far every class has been able to complete those. So you're right, it is singular in that in the first year, the torts office memo, those students did their torts office memo last spring, and now this spring will now work on their pleading, and then next year we'll work on their wills and trusts. So it scaffolds over time. So we have had, we're a very ambitious program. I will say that.
See that.
So, yeah.
I commend you. I mean, it's wonderful. And Justice, if I may make a quick comment, I thought I was put in the wrong group. I never thought I would ever consider a non-exam avenue, but I have to say, Associate Dean, that your presentation has been the first presentation that I've seen in these months that I've been on this group, where I might actually feel comfortable in exploring this opportunity and this pathway. But I would also say that I would feel comfortable if these students had more rigorous training in those projects as opposed to just the one project a year. For instance, if they were doing one a month, I'd feel way more comfortable in my comfort level with the non-exam pathway. This is Amy and I'm done speaking, but congratulations on this project. I'm looking forward to the results.
Thank you.
Thank you, Amy. Donna?
Thank you. So I just want to make sure that I understand the on-site portion of this. So I think what I heard was that that for each of the courses, that there is a monthly sort of intensive weekend for each of the subject matters, and that layered in addition to that, on top of that, are these once a semester lawyering weekends. Was I hearing that correctly?
Yes, and let me just explain. So each semester takes exactly the same format. Each month there is a residency. So 4 residencies a semester. The first and the third are always with the professors. The second one is always a lawyering skills. And the fourth one is their final exams. So so there are 2 with their professors, usually at the 4-week mark, and then again at the 10-week mark. In between that, there is a lawyering skills. And then after that are the final exams.
Great. Can you talk a little bit more? I'm not sure if I got distracted or didn't fully hear. Talk a little bit more about the capstone course. And the reason I ask, because Dean Funke, you haven't been well, I don't know what you've been listening to, but you haven't been participating in a lot of the presentations that we've heard to date. And when we've been talking about capstone projects, we've been talking about sort of significant written products that would be presented to ensure that the student has really grasp all of the skills and the information that has been taught by looking at this work or at this written product or a series of written products. So could you tell me a little bit more about your capstone course and what kind of products are required through that?
Absolutely. So one of the goals of the capstone course, because it does come at the end of the program in that last semester, is to make sure, first and foremost, we have 9 program learning outcomes. So one of the things that we have made sure across the semester is that those 9 learning outcomes are addressed somewhere. So one of ours is research, one of them is alternative dispute resolution, one of them is so we just make sure that has been built into the curriculum. Then over the course of the semester, think of it like a simulation, and a simulation of a young lawyer figuring out how to set up a law firm, how to get new clients, how to then handle the matter at each step, the decisions to make. So the types of documents that are created along the way are that. They are not a scholarly piece at the end, nor are they just one piece. They are multiple across the semester. They are also to engage in multiple discussions across the semester, to produce work product. But again, it's something that is more probably akin to, I want to say a trial brief or mediation brief, but an analysis of the case. But there are multiple. It's not one. Ultimately, and this was Dean Gardina's idea, and we of course have only had one group graduate, so hopefully we'll be able to do this. The idea was to get a group of lawyers to come in and assess the students. We've now run the course, and it has, again, it's worked really well, but we will, as we go on, tweak it along the way. But does that answer your question?
It does. Thank you. And I will offline reach out to the two of you and see, as I expect I will have this issue with our other presenters as well, but I'll reach out to you offline and see if there's any way I can, join your students for part of one of those weekend residencies and see what they're learning, because it sounds very exciting.
You're welcome anytime.
Thank you, Donna. Lynn?
Yeah, thank you. And thanks for the presentation. That was super interesting. Yet again, I feel like if I could go back and redo law school, maybe I'd join your program. And you may have just answered this when you were talking about bringing in practitioners to assess, but it seems like you were distinguishing between components where professors are involved and then lawyering skills where the professors are not involved. Who are your instructors, or who's running that?
Yes, thank you. So so with the ambitious focus of this program, you can imagine that faculty have to be handpicked and willing to do the amount of work, especially on a weekly basis. So we have a number of people who both teach in the courses and lawyering skills. We have some that just do one or the other. The group has been really hand selected. Some of them are academics from other law schools. Some of them are practitioners in the local area. So I have literally gone out and selected these people because I knew they would be really good at what they do and really serve the students well. So for example, we have a torts professor who taught torts at a traditional ABA school for, at least a dozen years, teaching our students because she loves the mission. We have an academic from Southwestern teaching contracts, but we also have incredible professors from our local community, public defenders from the Ventura PD's office who come in. So really it is a broad base. I think this faculty is extraordinary. I am so excited and grateful for them. I tell them as often as I can because the commitment to this is real.
And just is the mechanism that you hire them as adjuncts?
Yes.
Yeah, so our faculty model is exactly that. We do not, we have a couple of faculty that we've been able to bring on full time and they teach many courses, but especially our ground program is taught by local attorneys and judges. And we've been incredibly fortunate that we've had some of those same people willing to do the hybrid JD as well. So we have an adjunct model.
Thank you. Thank you, Mylin. Are there any additional questions? Okay, thank you both again for that excellent presentation. The next item on the agenda is a discussion of issues regarding scalability with some.
Do we have the rest of the panel? So Susan and
Oh, I'm sorry. I'm so sorry. I'm jumping way ahead. Susan? I'll just turn it over to you guys and you guys can go in whatever order that you would like. Thank you.
I think I'm next on the agenda, so I'll
Yeah,
go
okay.
next. Let me put my slides up.
I have Susan, Peter, and then Mylan.
Yes, thank you.
All right. Are my slides up? All right. Over the course of our last commission meetings, when we heard from Oregon, when we heard from Canada, when we heard from the Public Interest Fellowship, I left every single one of those meetings thinking, we already do that. And that experiential learning has changed a lot over the last years, even just over the last few years, but also over the last decades. And today's law schools really do prepare students to practice. And we could, as we've just heard, do even more if so much of the curriculum wasn't driven by the bar exam. And so what I'd like to do is start first with just a quick look at the ABA rules. And I have not, and I will not make you read them all, but there is a link at the bottom of the first slide if you would like to see the glorious detail of all of the requirements about experiential learning. I have excerpted a few of the basics to cover here, and this first slide shows us what we all already know. You have to take a legal writing class, a professional responsibility class, and 6 units of experiential learning under the ABA rules. And I want to focus today on that last part, the experiential courses totaling at least 6 credit hours in clinic, field placement, or simulated courses. And in fact, when we look at the next standard from 303B, what we actually see is that it's more than just give them 6 units of opportunity or require them to do some class that meets this requirement. It's much more than that. Law schools actually have to provide substantial opportunities under the ABA rule. At Loyola, we do this 2 ways. We require for graduation, all students to commit to 40 hours of pro bono work and at least the 6 units of experiential learning units. Now, in addition to sort of these basic sort of lofty descriptions, the ABA rules also include some more specific standards. And I've excerpted again, not everything here, but I wanted you to see some of the safeguards to ensure that experiential learning is actually a meaningful experiential learning experience where the students actually acquire meaningful skills in the right way. And again, I have excerpted a couple of things here to give you some illustrations that highlight these standards, not all of them. There are many, many more. The first one's probably the most obvious, and that is that the ABA rules require that we integrate doctrine and theory with skills and ethics. And that's not surprising. And you can see that the rule goes on here. I've excerpted part of it on the slide to include things that we would all naturally think about, that there's opportunities for performance, feedback, instruction, training, faculty contact, all of the good things. Also, a second example, and that is that there needs to be substantial lawyering experience under the ABA rules. And this one is that there's actual clients, or that the students are acting as third-party neutrals, or that we have a simulation that's reasonably similar. And while the live client experience is excellent, I want to put just a quick mention and plug in for simulations. And because simulations have a benefit that I think sometimes we think of them as not being as good as the live experience, and they can be excellent as well. The simulations can ensure a more varied experience, and I think that's important. But one of the things we've been looking at this commission that I think is equally important is simulations allow you to provide a great deal more consistency. You can be certain what kind of situations the students will face with clients when it is a simulated experience. Not to take anything away from the live experience, but a good example is something like when you're teaching negotiations. It can be very helpful to use simulations, which are carefully crafted scenarios that will raise the issues you want them to, and will require the students to have that consistent experience and that consistent learning in their experiential opportunity, because you have crafted it that way. So while of course, acting as a client, learning to act as a neutral are all very good experiences, so can simulations be, particularly when they're well crafted. I also just want to make a quick note that experiential learning like this, with either actual clients or acting as a third-party neutral or in a simulation, is not new. Loyola Law School has been hiring actors to act as clients for over 25 years. They were doing it before I got here in 1997. So it has been a long time, and technology and new software and new commercial products, even products that come standard with textbooks these days, are excellent at creating high quality simulations that ensure they neatly integrate with doctrine and theory and ensure that your students have a consistent and meaningful experiential experience. So they can be very realistic, and there is lots of good stuff out there. Now, there are also pages and pages of more ideas and concepts to put these protections into place, so that the ABA ensures that these experiential learning requirements really do meet the intended goals. I want to give you just one quick example from the illustrations. There are many, many illustrations. You can find them in the interpretations. Again, if you go back to that first link, there's lots of materials there, including interpretations. And one of them is what we call the no double dipping rule. And that's in interpretation 303-1 for those of you who would like to look at it closer. But for example, you take a class like legal drafting, which is a simulation course that includes both client type simulations, drafting, written projects, and client interaction and experiential learning components, all in one course. You may not get credit for both requirements. The ABA rules limit you to the student must elect that course, when taken, is either taken for the experiential requirement toward those units or taken towards an upper division writing requirement. It may not be taken for both. So this is a truly real and independent requirements, and it is different from the other things that the ABA schools are required to do. There are more details. There are more safeguards. I will spare you all of those details. I wanted to just give you a quick overview of the kinds of things that are the safeguards that are out there. But now I want to turn to sort of how students actually satisfy these requirements. And you'll see on the slide, I just have my quick summary here. How do students do this? Because obviously with 6 units and lots of choices, there are many things they could be doing. I should give a caveat right up front. Some law schools do require more than the 6-unit minimum. The ABA is a minimum. And so some institutions do more. Before we look at some of the details, I'd like to just point out that there's both an institutional and individual level in play here. At the institutional level, Loyola Law School is a big law school. So we have lots of offerings, lots of courses, lots of things. But I think it would be wrong to dismiss that and say it's not what lots of other ABA schools have as well. So while I'm about to show you a laundry list of lots of offerings and choices, it's typical of what other ABA schools also have to offer. And that's at the institutional level. Now, at the individual level, I want to sort of reinforce a point that we were hearing from the Ventura and Santa Barbara College's presentation, and that is that student success is wider and deeper in the experiential learning components than in classroom components. In a classroom component, the top 10%, the high performers, they have learned the classroom material at a very, very high level. And what we see in the experiential learning is somewhat different, and that is that struggling students can often be high performers. So those who do not necessarily have high classroom level skills have extremely excellent experiential skills. And I don't think it's a surprise to any of us that experiential learning is not at all the same skills that are required to earn an A in a classroom setting. Now, what is typical of both experiential and classroom learning is that students have a wide variety of interests today. But one thing is true, and that is the experiential learning opportunities are some of the most sought after things on campuses today. This is what students want to take. This is where they want to spend their limited units. And I want to start by showing you a variety of the kinds of things that are out there. And you'll forgive the font because I actually don't intend for you to read all this detail. I really just intend for you to see that the choices are abundant. And there are choices, of course, in the traditional kind of clinics, things you may think of as experiential learning. There are also externships. There are also private placements. There are also practica. Now, obviously, there are lots of choices here. This is no small part of the law school experience today. To give you an idea, even in the pandemic era, where almost nothing was ordinary, Loyola students served 10,000 clients and volunteered over 70,000 pro bono hours. And that's just in the pandemic era. Now, to give you an idea of the kinds of choices and things students are doing, the clinics on the left-hand or my left-hand side of the slide cover a wealth of subject matters. And that's why you'll forgive the small font, but that's what I wanted you to see, is that it includes an awful lot of opportunities in a lot of different areas. What I'd like to highlight for you is that it includes some less traditional clinics. It is not all limited to litigation style services. I think there is a stereotype of clinics that it is litigation services for the poor. And I think this list quickly disabuses that stereotype. We have clients that include administrative agency applications and appeals. We have clinics that are about policy advocacy, for example, how students might change education policy. We have dispute resolution clinics where students can learn to be a neutral. They can learn about advocating in dispute resolution. They can learn to conduct mediations. So what we do have, obviously, the more traditional offerings as well. We have plenty of opportunities for students who do want to represent clients in that more traditional litigation setting, and obviously in a variety of subject matters, and perhaps much broader than what many of us sort of traditionally thought of as a law school clinic experience. But clinics are by no means the only way to get experiential opportunities and units and credits. For example, we have the traditional externship, and everyone's familiar with the judicial externship of working for a judge, but you may not be familiar with that having been expanded to include working in government, state, local, and federal levels, and working in public interest placements. We also have at Loyola what is a little bit unique to us, private placements, where students can earn units by working in law firms or in in-house legal departments. We have approximately 100 students a year doing this, and it's extremely popular. We also have practica, and these are another sort of newer and less traditional addition to the choice of experiential learning options. This is basically a hybrid classroom and experiential experience. There's wide subject matter variety here as well, including some that are simulations, including some that are live clients, including some that are both. I'll give you just two quick examples off the long list here. One is that we have a Social Security practicum. We have classroom components where students learn about the Social Security process and applying for benefits. And then they actually help clients with real cases in procuring those benefits and filing those petitions. We also have at the top of the list on our practica here, we have a district attorney practicum where students spend one semester in the classroom and they spend one semester externing in the district attorney's office. And during that externship in the district attorney's office, these students actually act as prosecutors and actually prosecute real cases as part of their experiential experience. And this is, again, that's a year-long program. So it has fewer students, about 25. We have completing that program each year. There are many more. As you can see on the list, we have everything from tax to entertainment to all of the kinds of things that you might expect today's students to be interested in. All of these choices are a super important part of today's law school curriculum. And in fact, they're integrated into the curriculum. I think this was a fear when experiential learning was first introduced by the ABA, that it would become just an add-on, just give everyone this 6-unit class and dismiss it, make it as minimal and as little as possible. And it has instead turned out to be not that at all. And in fact, it's integrated into the curriculum. And the example I chose to give you here is that Loyola has something called concentrations, and also other schools have them as well. They call them a variety of things, sometimes fields of study, but they're a little bit like a major in college, if you want to think about it that way. These are for the students who have a subject matter interest. Some people arrive in law school with it. We have an evening program at Loyola Law School, which has a demographic of students sometimes coming from different areas in practice where they wish to get a degree and have a subject matter interest. Some day students in our traditional program arrive with a subject matter interest. Other students acquire it in law school. after their first year or second year, they develop an interest in a particular area. And we have what we have called concentrations. And you will see from the list on the slide here, these also vary. We have really broad ones like civil litigation, which is basically nothing other than not criminal. It's incredibly generic, right? But then we also have sort of specific ones like cybersecurity, which is far narrower. So it may be that they have a narrow subject matter interest, a broader one, but we have lots of choices for students here. These concentrations provide an extensive background in coursework, strong academic and theoretical base, and also experiential learning options. So they combine all of these things. Now, obviously, this is a resume booster. And that resume boosting feature incentivizes students to seek out experiential learning opportunities and to seek out concentrations where they can have this synergy of subject matter and experience. And in part, it's because it leads to experience in a field where they have a direct interest in working. And it also helps them with employment. They're obviously making connections with lawyers in the field that they wish to work in. And it also has created a lot more in law school networking. So a lot of what was done traditionally as a new grad, particularly for those of us like myself who went to law school many years ago, much of what we did as a new grad is now done in law school. Networking, getting connected, making connections in the industry you want to work in. Experiential learning is providing that. And students want even more of it. They love experiential learning and they would take even more of it. But the problem is how it fits in the curriculum. The challenge is if you permitted students to take as much experiential learning as they would like to, they would not be ready for the California bar exam. And let me sort of give you a chance to sort of take in the slide here, which is the 31 units of sort of what I call the required basics, which are basically bar subjects, and 18 to 22 units of recommended bar electives, also 6 units of experiential learning as required by the ABA, and also the 2 units of upper division writing requirement, which is also required by the ABA. Loyola requires 87 units to graduate. So let's start at the second item here on the list. And that's because it's the one near and dear to my heart, because as the bar director at Loyola Law School, I encourage every Loyola student to take 5 bar electives to be prepared for the California bar exam. And I encourage every student at Loyola to do this because our internal data shows that it improves bar passage rates. So I encourage them to take the 5 listed there: business associations, crim pro, remedies, trusts and wills, which for us is 1 class, and marital property. Those 5 courses total 18 of their 87 units to graduate. That's 21%. Now, if we add back in those 31 units at the top in that first item of the required basics, and actually, in all honesty, that 31, you should probably make that 35 because we should add in legal writing. I didn't because different ABA schools give legal writing different amounts of units and some incorporate it different ways in terms of being part of different requirements. But for Loyola, you could make that 31 units into 35 and add our legal writing class. That's now 40% of their units required to graduate. If you put those 2 together, you put the required and recommended classes for the bar exam, it's between 53 and 57 units. Because some students won't just take that 18 I recommend. Students that are struggling with standardized tests, students who have struggled with law school tests, I'm going to tell them to take a couple more. So they're going to end up with 20 or 22 units of those recommended courses. But the average student will end up with between 53 and 57 of their 87 units being devoted to preparing for the California bar exam. That's 61 to 65% of the curriculum is required or recommended for bar passage preparation. Despite all that, they want more experiential learning. They like it. It is sought after, but that's all they have left. They have just that small portion left for concentrations, for electives, just to explore what they might be interested in. This is their last opportunity for most of them. This is their terminal degree. This is the last opportunity to take a class just because you want to, just because you're interested in it. And right now, what drives that train is students want to do, they far exceed the minimum graduation requirements. They want more experiential learning. And let me show you some details on that. Now, many students do exceed this experiential requirement. But why? I think it's pretty simple, actually, but it's worth 2 minutes. Experiential learning reinforces the core of the first and second year. First year, they take legal research and writing for the whole year. Second year, they take a 1 semester class that we call ethical lawyering, which is half professional responsibility, half interviewing and counseling of clients, professional skills combined. So every student takes that 1.5 years of basics. And what it leaves them with is the 100% certainty that they need more. Because as they are exposed to the basic core skills of legal research and writing, of interviewing and counseling a client, they realize they need more, that they are not ready to do it on their own. So clinica, practica, externships, concentrations, these all become highly sought after because they recognize that 6 units is fine, I'll do that, but I have to do more if I really want to be prepared to be a better lawyer. So the experiential learnings often are also providing them the connection of why they came to law school. Because once they actually get out there, they get some insight into how the law they're learning in the classroom, how the doctrine, how the theory they're learning in their classes does or does not address the needs of real life clients. They also learn that experiential learning is more than just blending together of substantive and practical skills. It's also about building professional habits. And I could give you a list of 1,000 things, and I'm just going to give you a few quick examples. The first one, students learn lessons that they can apply to future clients. When they do experiential learning, they take that with them into practice and they use it. Students also learn to recognize and deal with client trauma. And as a subset of that, they learn to deal with their own stress when affected by the stressful situations of their clients. Students also work with those whose lives and circumstances differ from their own. And on my last example, students solve ethical issues and apply professional responsibility rules in real life settings. And all of these things, bottom line, means students take more than the minimum required. I want to show you a data snapshot of how that looks. And my apologies for the huge amount of numbers, and no, I am not going to read it to you. But I will just read the top line of the chart, which is we have clinics, we have competition teams, we have courses, that includes things like our practica. We have field placements, things like externships. And then of course, the last column is total. And this is for the last 4 years of data that was available. And it gives you, let me give you a little context about these numbers. Typically, we have about 200 students a year in field placements. And most of them are earning experiential units, although some of them are in field placements, also earning pro bono hours instead. Approximately half of our field placement students are in private placements in law firms or in-house legal departments. The other half are divided equally between judicial externships, working for the judiciary, and working for legal services or government providers. In the course column, in the center of the chart, there's a huge variety of experiences in there. Some of you may be familiar with the traditional sort of appellate advocacy kind of class, or the traditional moot court program. Today's law schools offer a lot more than that. We have obviously trial advocacy, negotiation, and sort of standard simulation programs, but we also have competition teams today that include a wide variety of subject matters. And that includes everything from international commercial arbitration to gender and sexuality law, environmental moot courts, human rights moot courts, and many, many more. Last year, 124 students earned units competing on these teams and in these kinds of simulations, advocating for clients in both transactional and litigation settings. over all of these kinds of subject matters and many more. But there are also many newer kinds of offerings. We have a program where students write and argue a real case before the Ninth Circuit, and the students actually write the brief. They are assisted by the lawyer whose case it is. They actually argue it in the Ninth Circuit. They don't prepare a lawyer, they don't help a lawyer, they do the advocacy. We also, as I talked about earlier, have our district attorney program where we actually have graduates acting as prosecuting attorneys. These are not all limited to litigation experience. We also have about 100 students a year in our conflict center programs, which are programs where they learn to interview clients, how to act as a mediator or neutral, and how to advocate in alternative dispute resolution settings. So over the course of 4 years, if you go down to the very bottom of the slide, we have a total of over 6,500 placements in experiential learning. The numbers complement the student testimonials we heard on this commission earlier from the public interest fellows. The students in every single one of these kind of experiential opportunities gives the same feedback we heard from those public interest fellows, that it confirmed why they went to law school. It showed them that they could and were developing the skills to be a competent attorney. And I don't think it's surprising the students have a high interest. I don't think it's surprising that we have more placements than we need to meet those 6 experiential units. I think that high interest is not limited to the graduation requirement or the ABA rules. I think it's because this is one of the few places where every single interest aligns. Law schools want to create practice-ready graduates. Students want in-law school training. They know they will not get it when they leave. And the public deserves and wants competent attorneys. Everything points in the same direction there, toward experiential learning in law school and more of these kinds of experiences. But one of the keys to providing the public with the competent attorneys they deserve is supervision. And again, I have taken a few examples to give you instead of trying to cover comprehensively everything that ABA schools do to provide proper supervision in their experiential learning programs. But obviously supervision is the key, right? Without it, the learning experiences will not be effective. And if we're going to create competent attorneys, we're going to do it with good supervision practices. There is far more out there than this. This is some highlights. Let me start with some of these chosen examples here, which show you what kinds of things ABA schools do, and Loyola in particular, to create and maintain a steady stream of contact between the supervisors, the law school, and the students who are in the experiential placements. The first is our MOU, or Memorandum of Understanding for Supervisors. And this agreement is very specific with details about the kinds of assignments that students are going to be expected to do, the required availability we have for supervisors, when they will meet with students, how often. We also have that it covers everything about communication, observation, feedback obligations, and more and more. Every ABA law school has an agreement like this in place with their supervisors. Loyola Law School uses a form that was developed by a consortium of California law schools and is very common to what most schools use. I'm happy to provide it to anybody who would like to see it. But we're not relying exclusively on the supervisors to make sure that our experiential learning is good. We are making sure that our supervisors are contacted. We're making sure that every semester, every student is checked on. But we also have student feedback and classroom requirements. The classroom requirements are every other week the students meet and they have discussions. And the most prevalent discussion is actually real ethics issues that have arisen. Confidentiality is very important. Other ethics topics also regularly come up at these classroom meetings. They're contemporaneous with the placement. So students bring the quandary they're currently facing. So there's discussions also of substantive law, theory, practice skills, ethics issues. And those classroom meetings also ensure that students are having a good experience. We also rely on student feedback, both formal and informal, to make sure that our supervisors are doing their jobs, that we have class discussions, we have evaluations, formal and informal. Students are required to answer reflection questions and complete daily journals during their placements. Those daily journals are reviewed every 2 weeks by faculty members. And the student feedback also includes sort of formal and informal assessment of their supervisors. Some of it, as you might expect, right? A formal form that says, rate your supervisor. How effective were they? And the sort of typical rating systems and an explanation of why. But we also have more indirect questions that we ask students that shed a lot of light on the supervisors. I'll give you one example. One of the things we ask students is, what are the top 3 things about your performance, good or bad, that you thought were most important to your field supervisor? That's very insightful as to how good the supervisor is. Now, there is not time to cover all of the terrific work students are doing in experiential learning. There is not time for me to cover all of the ABA rules or obligations or how we ensure that the experience is quality. I have tried to give you some highlights that give you some illustrations of how the rules work at Loyola Law School today. You will find more information if you're curious about any of our programs or practica or any of those types of things at the link on the slide here, which is just at the Loyola website. But before I end, I want to thank you genuinely for the opportunity to let you see what I've thought as a member of this commission, and that is that law schools can be a non-examination path. And that may be a path to licensure either by being a pipeline to a supervised practice that follows certain law school requirements or curriculum. Or it might be that law schools could directly provide the experience necessary to enter the profession and be competent and ready for practice. So I think we are a lot of the way there, but thank you for letting me show you what we do.
Thank you so much, Susan. I think a lot of us will have a desire to return to law school after some of these presentations. That was very helpful. Are there any questions from the commission members? Donna?
Since no one else raised their hand, I'd like to hear a little bit more about the field placements. I noticed that there were just about 200 of those per year, and I want to get a sense of how do those work? If I were one of your students, would I need to find a placement on my own? Do you bring them into the school? If you had 1,000 people who were interested in doing placements instead of course, participating in the practica, would you be able to place them? Just get some more information on how accessible these are for all of the students who are interested.
That has been the primary concern every time we have added a requirement. When the ABA added experiential, when we added private placements, all of these were legitimate concerns raised by students and faculty and administrators in terms of how will it be administered and will it work? And the short answer is it has worked flawlessly. We have had some small little, getting new programs started blips, as you would expect. But students get what they want. And part of that is, of course, that we have a wide variety. But within those 200 field placements, about half, so about 100 are in private placements or in law firms or in-house. Most students find that themselves, though we also have a matching program. We do both. So some students will come to us and they'll say, you know what? I just moved here from another state. I don't know a lot of folks in California, but I would like a private placement, and we help them find one. We also have alumni and employers come to us and say, we'd like someone. And so we have a placement and matching process for those who need it. Other students come to us and they say, I would like to earn my units in this legal department or in this law firm. And there's a rigorous approval process. And in fact, some law firms will not agree to the supervision requirements that are required to agree to in order to take the student in that placement. The other half, about 40, roughly half, about 50 to 60 students per year are in the judiciary. They are in judicial externships. And we feel confident that that program is obviously being supervised by judges and law clerks, and also by the faculty that we have full-time faculty at Loyola Law School who oversee our judicial externship placements. So we know what they're doing, we know where they are, and we have processes where we check on them to make sure it is satisfactory. The last 40 to 50 work in legal services providers or at the state or local federal government.
And
But we have not had a problem where students could not. And in fact, sometimes you can actually find a faculty member who is willing to convert a class to a practicum and add a component to do just that. We have a combination. Our practica are sometimes taught by adjuncts who practice in that area, alumni often. Other times they are full-time faculty who have a passion for that subject matter. It is their expertise. And they provide both the combination of practica and subject matter teaching.
thank you, Susan. Just one more question. For the ABA schools, how much leeway do you have? So, right, if California were to say we are creating this pathway and there needs to be 40 credit units, whatever, all right, I'm saying a random number off the top of my head, but we were to change the requirements considerably, and if there wasn't a bar exam, right, you wouldn't have bar exam courses, so that would sort of free it up theoretically, but do you have that kind of flexibility under the ABA
the rules are listed as floors. They are at least 6 experiential units. There's plenty of leeway. The restrictions are primarily curriculum driven by the bar exam.
So if the bar exam were different, so there is, I guess what I'm getting at is there isn't a parallel requirement that says a minimum of 31 credit units in bar exam courses.
Not for the ABA, not a parallel to the California rule that we saw for Ventura, and at least not that I'm aware of. The ABA regulations and rules are extensive, so I will give only the caveat that I have not read nor memorized the entire volume.
Thank you.
Thank you, Donna. Judge Rossi?
My apologies, I'm in the car on the way to do pickup. So I have my camera off, but Susan, I was wondering if you could talk a little bit, and this sort of piggybacks on what Donna was saying. I'm wondering if you can talk a little bit about if there are any difficulties in students of color or first gen students, or other diverse students getting the same supervisory expertise and practicum expertise that they need.
This is actually a really good question for Loyola Law School in particular, because while I did not include our diversity statistics in my slides, we are a very diverse law school. We have a large number of first gen students, including, and we have for many, many years. And so one of the things that when we talk about these programs, because there are so many of them, the opportunities are well distributed. Right, so folks actually have subject matter preferences that they will self-select into the particular clinics, practica, and opportunities that they want. But we have not had a problem with a student who wants a private placement not being able to get them something. And the same thing with, we have not had a systemic problem with, once students come to us with placements, that we can't approve them. We have about 100 students a year in private placements. So to give you an idea, we have about 300 in a class year, give or take. So that's a large percentage of the class. Now, what I will see is some students choose not to do the private placement because they are working. So some students that are working may elect to do some of the other kinds of experiential opportunities, though some do both. Some days of the week they work, and some days of the week they go to their experiential learning requirements. So it is possible to do both, and we've not seen anything to suggest that there is a disparity in which students take which kinds of programs. It's primarily subject matter and interest level driven.
Great, thank you.
Thank you. Amy?
Thank you, Justice. I'm not so much concerned with the quality of these programs. I think they're great. It's the frequency that I'm still having issues with in terms of a non-exam pathway in my mind. And I agree that these types of internships and these types of practical experience, they're, I mean, a dime a dozen. You can get one at the local DA county's office. You can get one at the Attorney General's office, you know, for the state of California. I remember bringing that particular internship to my law school over 20 years ago. I was the first to have done it at my law school. And I think we're not going to have a shortage of those types of offerings for the students. But it's the frequency and the duration that concerns me.
The frequency is much higher than it was historically. Many more students are taking many more of these kinds of opportunities, particularly for things like the practica, where there is a simulation or live client component added to a class. Those are very popular, and those do increase the frequency because they allow a student to take both an experiential component and a classroom component. Students are often taking an experiential component as often as they can. The frequency is solely limited by they have to get ready for the California bar exam, nothing else. It is not limited by their interest. It is not limited by their offerings. It is limited by they have to take business associations for 4 units or they will not know the subject matter.
Thank you. Jackie?
Yeah, I just wanted to speak to that as well and echo what Susan said. What limits our ability to offer more rigorous and long-lasting and frequent practice opportunities is entirely content-driven, especially for those students who struggle on standardized tests. They come so primed and worried about the bar exam from the moment they step into the classroom that it's even hard for them to take time away from that in order to truly engage in the experiential opportunities that are available to them. So what you're hearing now is built around the bar exam and what we can create. It isn't, if you let your imagine run wild, what's possible to create.
I think I would just add too that sometimes we forget that it can also be students at the very top of my class who have little concern, frankly, about passing the bar exam, are often driven away from the experiential unit requirements and are taking all of the bar recommended classes anyway, because they have a high prestige job or clerkship or something that they are terrified they will be embarrassed by not passing. So this is not a problem of just the bottom lower law school performers. It's a problem at the very top law school performers and everyone in between. Students want more of it. We know it benefits them, but there is not enough room for more, especially because clinics can be high unit value and can use up all of your elective units. For example, we have a juvenile justice clinic, which is outstanding and does amazing work that you've probably seen in the news. But it's many units each semester between the classroom and the live client clinic component. Students really can't take much else along with that. They got that and a bar elective and they're done.
Is there any type of program that assists the students at the beginning of their law school experience to try to sort of get an idea of their interest and map out what would be possible different classes or curricula that they could take throughout their time there?
I don't know that we try to encourage them because most of us recognize that the JD is, while it's a terminal degree and a specialized degree, is a degree to practice law. And so I don't think that we're trying to force students to choose a concentration, particularly those who do not have a particular subject matter interest. We have some broad ones, right? We have civil litigation. So perhaps that is good for those without a particular interest, but a lot of students will find their passion in practice and not in law school. So I think that we are careful to sort of straddle that fence and to say to some students, if you came here with an interest, we will help you meet it. And here's a course of study, here's a concentration, here are things that might help you reach those goals. But if you came here without that, we will give you a fantastic general practice degree and you will be ready to be a lawyer.
Thank you. Any additional questions? Okay, thank you. There are no additional questions at this time. And so our next presenter we'll welcome is Peter Fear.
Hi, good afternoon. Let me see if I can get my screen shared here. There. So my name is Peter Fear. I'm an adjunct professor at Oakbrook College of Law. I'm a practicing attorney, and I was really enjoying hearing the various discussions of ways to encourage the practice of law and learning about the practice of law while you're in law school. I will frequently actually have interns or externs, as you might call them, in my office who just want to figure out what it's like to practice law, both pre-law school and then while people are in law school. So I was enjoying that. But I'm going to tell you a little bit about Oakbrook College today. Oakbrook College is a small distance education law school. It's actually classified as unaccredited correspondence law school by the California State Bar. Of course, in this day and age, nobody actually sends anything in by mail, so that means that almost everything we do is online. Our first class enrolled in 1995. Since that time, we have had a little over 300 graduates, so we're small, and we have a real focused mission as to what we do and how we do it. We're a little bit different than some other correspondence schools in that we have fixed academic terms as opposed to rolling enrollment. So what that means is that all of our first year students start in August every year, and then they finish up 50 weeks later in July. And they then take the first year law students examination. Hopefully they pass it. And then they start their second year studies in January. And they will go do that for 50 weeks, take a 2-week break, and then start their third and fourth year studies. It's a 4-year program. So that's kind of how the structure works. We do, at the beginning of the course work, we do an in-person orientation and introduction to law course. That's required for all new students. And we do that at a conference center that we rent out and have all the students come in and they get to meet each other. That's one of the differences that you might have from many other correspondence law schools. So in addition to that introduction to law course, we also have several of the courses that take place at the same time, including a trial advocacy and appellate advocacy course. So in addition to our legal writing courses, we have legal writing courses that are required for all 4 years. So we have legal writing 1, 2, 3, and then in the 4th year, there's a senior seminar paper that students are required to write. In addition to those, we also have a trial advocacy course, an appellate advocacy course, dispute resolution, and the opportunity for doing legal externship, which you can earn up to 4 credits in a legal externship. As was noted earlier, the requirements, our requirements are that we have at least 4 credit hours of experiential learning. So the way we do that is we require that all students take appellate advocacy and that they take either trial advocacy or dispute resolution. They can take both of those if they would like, but they have to take at least one of those. Okay, so I am the professor for appellate advocacy, and I say professor, I'm kind of the one who kind of guides the course, but there are actually several other professors or other people who come in and help us with the course because we need people to serve as judges for the students. So the focus on appellate advocacy, of course, and I'm going to talk a little bit more in depth about how we do it, partly because we're a correspondence law school, and I think a lot of people kind of wonder a little bit about how some of these, how the correspondence law schools do things. So, of course, we want to focus on the skills that are necessary to make an oral argument before an appellate court. As I'm teaching it, I'm often thinking to myself that the skills that they're learning there are actually very similar to the kinds of skills that they need to argue a motion in front of a trial court as well. So the skills are pretty important for them to learn. And as I mentioned, I'm a practicing attorney. I practice in the bankruptcy area. So if any of you do bankruptcy, you know that there's a lot of motion work required. So I have to end up making those kind of arguments in court frequently. And I see that the skills that my students are learning through that. Okay, so the way this is structured, in the first semester of their 3rd year, they have to take legal writing 3. And legal writing 3, they have to write an appellate brief. We use the same fact pattern and the same case for the appellate brief as we do for appellate advocacy. So the course is structured around an in-person workshop that takes place at this conference that I mentioned. And so what we do first is we have them do about 6 weeks of preparatory study before that. The preparatory study includes readings and lectures on oral advocacy, and assignments, and drafting an outline for oral argument. They also have to draft up anticipated judge questions and think about how they're going to respond to those, and actually come up with thought through answers as to how they might respond to questions. And then we also do Zoom meetings with the professor, some of which are just to kind of talk through the topic and how this works, and then some of which are actually practice oral arguments. And what I'll do actually frequently is I'll record those arguments, and then we'll watch them back with the students so that I can then point out things. Okay, you see how you did this? You could do a little bit better job with this. So that's some of the techniques that we used before the in-person workshop. Then at the in-person workshop, we spend the first 3 days of that doing really intensive moot court preparation and discussion regarding how to best make these arguments. And then usually on the 4th day of the in-person workshop, they will do their final arguments, which the final arguments are in front of a 3-judge panel of practicing lawyers with appellate experience. And so that's how that works. Okay, so that is appellate advocacy. And then trial advocacy is the 4-credit course taught by our Dean, Douglas McKelvey, who's a practicing trial lawyer. This course is made up of 7 2-week lessons, followed by a workshop at that same conference that I was talking about. So basically what we do is we figure out what the date is for that conference, we back up 7 weeks, and that's the course progress for this particular course. So during the pre-workshop preparation, study and preparation, they have readings and lectures on trial advocacy, and then they actually will submit at different points at the end of various lessons a video presentation of themselves giving an opening statement, doing direct and cross-examination of lay witnesses, direct and cross-examination of expert witnesses. They have to find a friend to serve as that person, but that's the way they do it there. And then a video presentation of the closing argument. So then after they submit those, the professor will call them and discuss with them points of improvement for their presentation. So then at the end of the course, they come again to that conference center, and they spend an intensive time on the first 2 days. Usually it's how it's structured, depending on the number of students. We have to extend this a little bit. The first 2 days, they spend an intensive time working further on their opening statement, their various examinations of the witnesses, who we actually bring in people to serve as the witnesses for that. And then on Wednesday or potentially Thursday, depending on the number of students, they conduct a full trial for a final grade. So they're assigned sides, and then one side will be the plaintiff, one side will be the defense, and they will do that at the workshop. Then they get a final grade based on how they perform at that time. So another, I think, very valuable source of experiential learning for students is a legal externship. We provide a process to be able to get credit for this, but we also encourage students to find a practitioner or find somewhere that they are able to work while they're in law school, because the practical experience that they can gain by that while they're learning the black letter law is really invaluable. The way we structure our externship program is they can receive up to 4 credit hours for that. And what they have to do is they have to find a supervisor who's willing to supervise them in either judge's chambers or a private practice. And then they have to put together a proposal that they submit to the college's externship supervisor, who right now is our academic dean, Robert Barth. And so that proposal has to be very detailed, has to talk about the different educational objectives that the student will be achieving while they're doing that. It has to be talk about what area of law they're working in, how they're learning about the functioning of the legal process. It has to talk about the type of time and effort that would be expected from the student in pursuing those educational objectives, the work products that they might come up with, and the amount of time that they would be doing that as well, because they have to spend at least 90 hours of actual work to gain 1 hour of credit. And there's, and then the way the process works after that is there are periodic reviews by the supervising faculty member with the supervising attorney to make sure that everything's going well. And then at the end of that process, the supervising faculty member will get the report from the student and from the supervising attorney and assign a passing or failing grade. Dispute resolution is also done in taught by our Dean, Douglas McKelvey, as well. And he's a certified mediator by the American Academy of Attorney Mediators and really has a heart for this. And so he does an excellent job teaching that. But during the course of that, they will write several papers on the topic of negotiation. They also will have a course of lectures and readings that they need to read. And then they're assigned several different disputes and assigned one side or the other to negotiate with another student to come up with a resolution, and they're given confidential information and their general information to be able to come up with that, and given various points for how they do that, how they come up with a good resolution. And those can be done by, in writing or by phone or by video conference, depending on certain techniques that they're learning in those courses. So that's kind of an example of some of the experiential training that we do. So, and that's all that I have. Do you have any questions for me?
Thank you very much, Peter. I don't see any hands up, but I was wondering on the last slide about the legal externship, if there's any assistance in placement for those externship opportunities.
So if a student tells us that I'm looking around for the button to stop sharing, there you go. If a student tells us that they're interested in that, we will informally use our connections to be able to do that. And we have a lot of students who have been able to do that. I personally do that frequently in my law practice. And I just think it's a wonderful way for a student to be able to get that practical experience. So we don't have something formal set up, but if a student asks for that, we'll basically have networks of OBCL alumni who are very interested in that, and other people who are friendly to the school and professors who'd be interested in doing that. So that's how we usually handle that.
Great, thank you. Are there any additional questions from the group? No, I don't see any, so we'll now turn to Mylin.
Thank you, Justice, and thank you for inviting me to speak about Lawyers for America. Is everybody okay seeing my screen? Okay, so I'm a clinical professor at UC Hastings. Part of my job is being the academic director of Lawyers for America, which is a 2-year fellowship program that's currently unique to UC Hastings. Here's the overview. It's made up of 2 years, the training year, which is the fellow's 3L law school year, both semesters of that 3L year, and it's followed by a service year, which is a paid post-grad year externing, the training year is the externship, the post-grad year is a paid position at the same placement. And I don't know if I heard Susan or Peter define externship, but when I use the word externship, and typically in law schools, it means working at a law office, a field placement for academic credit, as opposed to an internship, which is when you're, maybe volunteering there or getting paid there, but you're not getting academic credit units towards your graduation. LFA is a 501c3. It was founded in 2011 by two UC Hastings law professors, one of whom is now our dean, David Fagman, and the other of whom is Marcia Cohen, who has been a professor at Hastings for many years and is now the executive director of the 501c3. So LFA is actually its own nonprofit. It was incubated at Hastings and it has been implemented at Hastings. I'm employed by Hastings and I'm the academic director there. So far, we've had 9 cohorts of fellows. The first was the class of 2014. We are a small program. The cohorts have been between 3 and 7 fellows per year. LFA has a 3-part mission. The first is to prepare law students for practice, the same theme that we've been talking about here all afternoon and in many of our earlier commission meetings. The second part is to create postgraduate employment opportunities for the law school where LFA is implemented. You can imagine in 2011, 12, 13, 14, when the legal market was pretty constricted, this was a core part of the mission, and it, in fact, has made some difference to our employment numbers. And then the third part of our mission is to improve access to justice by putting good 3Ls and good lawyers in nonprofit and government agency law offices, where they, which offices might not be able to afford hiring someone for those 20 months of the fellowship. So breaking down the first part of the mission, and this is really what we've already been talking about quite a bit. You know, the idea was to adopt the medical model of training and education and to move out of the classroom and into more of a practice-based education model and more experiential model, and have students graduate from law school and certainly from the fellowship with really strong skills that would be needed in practice. So UC Hastings has a very strong, robust, long-standing range of experiential offerings. Pretty much everything that Susan described at Loyola holds true at Hastings. So we have quite a few in-house clinics, quite a few hybrid clinics, and lots of judicial, legal, corporate counsel externships. We have a whole range of those. LFA takes it one step farther. Sometimes we call it an externship on steroids. And in many ways, it addresses what Amy has been piping up about with respect to frequency and duration. Here it is, Amy. I got you. So here's how it works for the fellow. During their 2L year, actually right now in February, for the class of 2023, they apply to the placement site or sites that they're interested in. If they get hired during their 3L year, they work an average of 24 to 32 hours a week as an extern. As mentioned, externs earn academic credit. So depending on how many hours they're working per week, they're earning a certain number of fieldwork units per semester. So between 6 and 8, so you can earn in your entire 3L year up to 16 academic units toward graduation. That's the bulk of the units that you're earning during your 3L year. In addition, you take a total of 4 classroom units that are related to your field work. So if you're in an environmental placement, you might take water law, you might take land use. You'd be strongly encouraged to take admin law because that's super useful to the environmental placements that we have. The idea being that your classroom work is complementing and enhancing your field work. You graduate, you take the bar exam, and then you go back to the same placement for your postgraduate year. And here it operates, a little similarly to what we heard about from LSFN. You're working full-time at this nonprofit or government law office. You're earning a $42,000 salary and you receive a stipend for health benefits. The stipend, it's, I think a little, maybe between $4,000 and $5,000. You can pocket that if you're receiving health benefits through your parents, your spouse, the VA, whatever it is. But it is a relatively low salary, annual salary for your first year out of law school. One of the selling points is that it begins as soon as you want after you've taken the bar. So you don't have to wait to get your license to start earning your salary. So how LFA works for the placement sites, they pay an administrative fee to Lawyers for America, the 501c3, that covers the salary, the health benefits stipend, the admin costs, the payroll taxes, all of that. They're the ones who do the hiring. They collect the applications that we provide them, and they do conduct the interviews, and they choose who, if anyone, they want to hire during that during the 2L spring to start in August of the 3L year. And then, of course, they supervise the 3L fellow consistent with our academic regulations and the ABA standards that Susan described. So all of those components that Susan described apply to this because it is a 2-semester externship during the 3L year. And of course, they're doing all of this in collaboration with faculty, meaning me. And that's not nothing. As Susan said, it takes time and effort and some training often for the supervising attorney who is a practitioner to be the kind of high quality supervisor that we need in order to ensure that the 3L fellow is learning enough on the job to warrant the many fieldwork units that they're earning towards their graduation. And then in the postgrad year, the fellow is technically an employee of LFA, but of course they're performing their work at the placement site. People often ask this question. There is no obligation to hire the fellow once the fellowship is done, although we've had pretty good results there. They often like our fellows so much that they do hire them permanently after the fellowship has ended, or even sometimes before the fellowship is over, they will sort of preemptively hire the LFA fellow. I thought you might be curious about where we partner, what placements we have. The ones where you can see the logo are the folks hiring from the class of 2023 right now. You can see that they concentrate in the area of environmental law and then criminal justice. And I can explain why offline if you're interested. And in addition, we recently started partnering with Open Door Legal. That's going great. We've had past placements. I put a few of them in the corner there, the Berkeley City Attorney, FDAP, Contra Costa, Public Defender, and there may be a couple others that I'm forgetting right now. Here's how it works. The fellowship works from the perspective of the law school. There are 2 general groupings of responsibilities and activities. The first are programmatic. So we have to recruit the fellows from the student population. We screen the applicants a little bit. We manage the application process. We coordinate with the site to get the interviews scheduled and done in time. There is a little bit of site recruitment that I do, not a lot, because as I'll get to in a minute, we have plenty of sites for the student demand. And then there's also a good amount of advising going. I think it was your question, Justice Guerrero, letting even 1Ls know that this is an opportunity and how they need to map out their 2L year in order to be ready to apply and participate in LFA, meeting all of their, getting themselves hired and meeting all of their graduation requirements. And then there are the responsibilities that largely fall to me as the academic director, which is to supervise the fellows in a way that meets all of those pieces that we saw that flow from the ABA standards as well as Hastings' own regulations. And those mostly just boil down to ensuring that there are sufficient learning opportunities, again, frequency and duration for the LFA fellows during their 3L year, such that the up to 16 units of fieldwork credit are warranted. That includes the opportunities for reflection and self-assessment. This is right out of the ABA standards. So I do my site visits. I go to each site in the middle of each semester. I support and communicate with the placement supervisor. Sometimes I do some trainings. I troubleshoot all of that. There's a fair amount of support of the supervising attorney, particularly if they're new. I actually, looking up at programmatic responsibilities, I do want to note that where I say recruit sites, and I said that it's not a ton of work. What is work is vetting the sites, which I think has come up earlier, ensuring that the partner placement site is, I don't want to say worthy, but that they're going to provide a meaningful learning experience to the fellow. That is time consuming and often requires multiple visits. Okay, so then these next couple of slides are kind of loose ends, but things that I was thinking about that were pertinent to what we're doing on this commission. Just people want to know about this. There's a 4-party contract that maps out this relationship among the nonprofit LFA, the placement site, whatever that law office is, Hastings, and the individual fellow. This is pretty notable. As part of that contract, the placement site has to agree that if the fellow doesn't pass the July bar after they graduate, and the fellow is required to take that first bar following their graduation, if they don't pass, they get a second shot. I mention this because it's a significant selling point for the program. In terms of practice readiness, so we've heard that students who engage in experiential learning in law school tend to be more practice ready than students who don't. And this LFA is just taking that one step farther. They've spent a tremendous amount of time in their externship with close supervision, not only from their placement site supervisor, but also through myself or whoever's running the externship program that they're enrolled in. So what I have seen, what I've heard both from the placements over the almost 10 years and from the fellows who have completed the program, is that they're in a much better position. They've learned a lot more, they've practiced a lot more by the end of their 3L year than someone who's taken a 1-semester externship. Part of it is that they've had 2 semesters, right? But it's actually more than twice the experience, because if you can stay at the same placement for the full academic year and you're working during most of winter break, which our fellows tend to do, you get more and more responsibility. Your lawyering tasks become more and more sophisticated. You get to see the trajectory of a case, many more stages of that case if you're around and working in the office for longer. In addition, you've become inculcated in the the culture of the office, so you know where the office supplies are, et cetera, et cetera. So what we find is that fellows after their 3L year, when they come back the following August or September, they're having a very smooth transition into the office that they're already familiar with. In the criminal placements, they just get a caseload on their first day, which is not necessarily going to be true of all post bars. I want to note an important, I think I'm going to call it a drawback of this model as currently practiced in today's environment. I don't get as diverse a pool of applicants for LFA as I was expecting, and certainly as I would like, and as we ought to get. I firmly believe that students of color and first-gen students benefit from this program because for all the reasons that those populations benefit from experiential learning generally. They have the opportunity to use the many, many skills that they already had before they came to law school that may not be as deeply valued in the classroom. So they can demonstrate their abilities day after day in the same law office and build their confidence day after day by doing actual work, as opposed to sitting in a classroom and freaking out about a high stakes closed book, time limited exam that relates almost not at all to practice. So for those reasons, I thought that LFA would be a really good match for first gen and students of color. That has not proven to be the case. And here's why I think. It's because of the bar exam. Everybody's so focused on doing what they need to do to get themselves ready for the bar exam. And the more you suffer from stereotype threat and the more you're getting the messages, you need to take the entire curriculum, business associations, wills and trusts, community property, all these things that you're never going to need when you become a PD, the more of that pressure you feel, the less likely you're going to separate from the herd in the middle of your 2L year and say, I'm going to do this crazy thing that only a few people do. So that's one. I'm going to join the bandwagon of folks who are noting that the current bar exam model is not good for many, many, many law students. And then just to, I guess, highlight that, there have been changes in LFA, curricular changes in LFA as a result of the extreme concerns that UC Hastings had about bar passage a few years ago. So in its original conception, the first few classes of LFA fellows had to take 16 full fieldwork units, and then they had 8 classroom units. So it wasn't 12 to 16 fieldwork units, and it wasn't 4 classroom units. It was a total of 24 units during their 3L year. And for most of them, that was their entire 3L year. They didn't take anything else. But in response to the bar pressures, we had to reduce that to its current constitution. So, and then because they were basically just doing LFA, they spent a tremendous amount of time at their placement site. So I looked back through some of my records, and I noticed in a spreadsheet that one fellow had done 1,420 fieldwork hours during her 3L year at a PD's office, which is over 45 hours a week. That's an amazing amount of learning that she was benefiting from. And as mentioned, we had to reduce the curriculum of LFA, the fieldwork units, et cetera, in order to permit students to take more bar classes so that they could pass the bar the first time around. I gave some thought to, what does this mean for us as the commission? Because this is, it's sort of a fun little program, but what can we learn from it? As I said, there is more placement demand for fellows than there is student interest, even despite the burdens of providing high quality supervision at the placement. So there does seem to be some appetite. I do not know that I would go as far as LSFN did to say that there are enough offices out there ready to take brand new grads, let alone 3L fellows, and provide that type of labor-intensive supervision that is needed to get a grad or a 3L ready for practice. Right now, the big limiting factor on my program is student interest. I don't have enough students who want to do this, or they want to do it, but they think they can't do it. They can't do it because I won't pass the bar. They can't do it because they can't live on that salary. That has a big impact, including on first gen and students of color, particularly. They're graduating with a lot of debt. They don't see $42,000 in the Bay Area as being feasible. But it is, I think, in largest part because of the bar exam. If this became a pathway to licensure, some variation on this, they would be breaking down my door. As I mentioned, the placement site selection, vetting, and matching, and we've talked about this already, that can be time consuming. The faculty time for this program is significant. So I don't think we can just say, okay, we'll have all law schools take on this pathway without recognizing that that would be a significant investment of faculty time if it's going to be run by faculty. And then my last point is, I think it was kind of covered already, but we are operating within these regulatory systems. If we're going to add another set of requirements coming from the state bar, that's going to be something for law schools to attend to. Although I will also note that when the TFAR recommendation came out, at least my school, embraced it. I think participated in generating the recommendation and then embraced it. I think that was for 15 experiential units. Does anyone remember if that's what it was? So I don't think it would be super onerous. So this is my closing slide, but I did kind of put in there who I am because it explains why I wanted to be on this commission and what I've learned. So yes, I do LFA. That's the smallest part of my job. Another part of my job is teaching an in-house litigation clinic. I teach an employment law clinic right now. So I have a good view into that. And then I teach evidence. So I teach a bar course. And so I feel this tension and I see what's happening to my students in each of those settings. And I teach 100 evidence students. And I don't think that when I do that, I am preparing them to be members of the bar in the way that Lawyers for America or my in-house clinic does. So I just wanted to end with that final advertisement for really seriously considering something that looks less like the current bar exam and more like what people have been talking about this afternoon. Thank you.
Thank you so much, Mylyn, for your presentation as well as the insights that you've provided and your comments there at the end. Are there any questions from the commission members? You covered it all. Thank you. We'll go on to the next item on the agenda, which is now the discussion of scalability issues. And a snapshot will be provided of the current testing population to assist in our discussion.
Yes, and I'm going to sort of go through the next couple of items on the agenda in one presentation. And I'd like to thank Peter for your, you can, Devin, if you want to go ahead and send Peter back to the attendee. Thank you so much.
Thank you.
Thank you. Let me share my screen. Okay, so we all know where we are today. So what I wanted to start with is you'll remember this slide from November, which were our guiding questions as we go through thinking about a non-exam pathway. And it's all sort of dovetailed into everyone's presentations so far today, but thinking about minimum competence, thinking about consistency, thinking about equity, thinking about scalability. And this is kind of how I'm going to walk through a lot of what I'm going to kind of summarize today. So just wanted to review this. These were our guiding questions that we went over a few commission meetings ago, and they're going to come up a lot in looking at these different models today. So thinking about scalability, what I've pulled together is first-time exam takers by applicant type for the past 20 years. So we're only looking at first-time and not repeat applicants, right? Because we're talking about a non-exam pathway. So looking at this, what is this universe sort of trending in these different buckets? Applicants from our California law schools, applicants from out-of-state law schools, out-of-state attorneys, our foreign JDs or attorneys, law office study, which is, as you can see, a small number every year, and then other. And you might say, well, what is other? And some of this, the other applicants are law schools that are now closed. So law schools that don't operate anymore, so they don't actually get pulled into either of the law school buckets, or something like a number of disbarred attorneys might be taking the exam every year. So others just sort of a catch-all category. Let me know too, or someone let me know if I can't see your hand. As I go through any of this data, you have a question. And we're just looking roughly year over year, it's about 60% from California law schools, 15 to 20% from out of state, 10 to 15 of those out of state attorneys, and then about 5% foreign JDs or attorneys. So just looking at those, the large numbers there. And this is just a graphic of the same data because some of us really like visuals, and kind of looking again at those buckets with the California law schools obviously making up the largest percentage of our applicant pool. So I'm going to summarize, and Susan and many of the speakers today actually sort of summarized a lot of these models that we heard from others today. But top of mind is Oregon, because the Oregon Task Force recommended 2 alternative pathways to licensure, and both are now, you probably might have read about it because it's of special interest to you on the Blue Ribbon Commission, but they're both moving forward with their court now. So one pathway is expanded experiential training in the curriculum at Oregon State schools, ending with capstone projects read by their Board of Examiners. The other pathway is for their out-of-state applicants, which would be a supervised practice pathway, 1,000 to 1,500 hours. They went with hour requirements and not months, because they know that it might be possible that the supervised practice is by several different supervisors. So they're thinking it might be easier for them to accumulate different hours and different chunks of hours. And that is culminating in a review of work product, again, by the Board of Examiners. And for that pathway, the UBE exam will still be an option. So people could do supervised practice, or they could take the bar exam. This is good. Again, kind of dovetailing, it's perfect synergy today with what Maya Lynn was just presenting. So we heard from the Legal Services Funders Network at one of our prior meetings about this idea of a pilot, and which is sort of similar to Lawyers for America as well. So we have a pilot program open to California law schools and applicants who want to pursue careers in public interest law. We can refine the duration. There'd be a first-year salary on par with public interest attorney salaries. We could open it up right now. The Legal Services Funders Network is open only matching orgs and interest in the Bay Area, would open it up statewide. The oversight would be done on our end at State Bar or in partnership with organizations that would help with the matching. There'd be learning sessions kind of maybe modified on what the Legal Services Funders Network already has, and then our State Bar regular first-year attorney requirements. There'd be a midterm, a final evaluation, supervisor's recommendation, similar to what we've done with provisional licensure. And then we can add on top of that a mini exam, depending on how we're feeling about all these different bullet points and testing for minimum competence. So we heard, that's a summary of what we heard from LSFN a few meetings ago. And then the Canadian articling programs. So as a reminder, Canadian jurisdictions have articling as part of their pathway to licensure. Articling is a supervised apprenticeship between 8 and 12 months long the bars of Alberta, Nova Scotia, Manitoba, and Saskatchewan, in addition to their articling, they use something called PREP, the Practice Readiness Education Program developed by the Canadian Centre for Legal Education. In addition, PREP is a series of modules, workshops, some of them virtual, some of them in person, culminating in a capstone simulation. So it's sort of in place of any kind of exam, they have this kind of modular education requirements that the applicants go through in addition to articling. The Law Society of Ontario doesn't use the PREP program. In Ontario, they do take 2 exams, the barrister and the solicitor exams, in addition to the 8 months of articling. They have 2 branch programs as an alternative to articling, the integrated practice curriculum where 2 law schools offer experiential training in the curriculum and a 4-month placement. And the law practice program where 2 law schools offer 4 months of simulated training and then 4 months of supervised work. So there's 2 small populations in Ontario, integrated practice and law practice in place of the articling, but providing similar experiential training. And I know I'm actually summarizing a lot of the, I'm kind of distilling it very quickly. So again, if you need me to stop for questions, let me know. So what I'm going to do now is summarize what could be possible pathways if we're moving toward a recommendation for a pathway for a pilot today. So a possible pathway is built on our current provisional licensure model. So currently we have provisional licensure. We had it in the original pathway for 2020 graduates during the pandemic. And then we expanded it to open up to people who scored 1390 to 1440 on the bar exam in the past 5 years to have 300 hours of supervised practice to be able to be licensed. So I'm kind of looking at those guiding questions that we started off the presentation with, and then answering how does the model serve to answer those questions. And I've added additional one, which is there an exam? Just because I think that is something that we need to think about, like even if we have this pathway without a bar exam, is there some sort of assessment or exam? So for the provisional licensure model, there is an exam. You had to have a certain score on the bar exam to even qualify. Scalability, we look at supervisors, and the provisionally licensed lawyer, it was their burden to find a supervisor. So that's how that was handled in terms of scalability. Scalability in terms of resources like Office of Admissions, the state bar resources. Well, we built an infrastructure for the supervised practice for this small group and how to collect their, their hours and their timesheets. We have that infrastructure that we could build on. The consistency question was very varied. The provisionally licensed lawyers acquiring their own supervisors leads to something that could be an inconsistent experience. And in terms of access and fairness, again, the inconsistent availability of supervisors is not equitable. Telling, folks, you go out and find your own supervisor, it was in terms of what we were offering during the pandemic, I think a wonderful option, but there's an inconsistent availability of supervisors when the onus was on that provisionally licensed lawyer to find a supervisor. In terms of minimum competence, there was the bar exam already to qualify, and then you had the supervised practice. All right, so that's one model. And again, since I'm sharing, I don't see hands, but someone yell at me if there's a hand.
I'll keep you posted, Audrey.
Thank you. And you didn't even yell at me. So these are the 2 different pathways that we have currently. So the original, the 2020 grads who were allowed to do supervised practice and then pass the bar exam. So we had 915 of those accepted into the program, and then they're passing the bar exam along the way, right? That program was temporary for 2020 law school grads. They didn't have to do the 300 hours. There's still 272 in the pathway, and then 411 of them didn't complete the application. They might have started, they might have thought they wanted to do this option, and for a variety of reasons, and maybe some of them could have been not finding a supervisor, they did not complete. So they expanded, that's those who are becoming licensed now. This is the data for the expanded program. 673 of them were accepted, 15 of them still did pass the February bar exam. 1 passed the July, 383. So more than half now have completed their 300 hours. There's still 346 in the pathway. And then 25 of them did not fully complete their application for the expanded program. So in preparing for this meeting, we were asked to look at what if we did another pilot? What if we did a provisional licensure pilot based on a cut score of 1350? So for the national median, looking at all the bar exam cut scores across the country is more like a 1350. So what if we went back and then we could limit a pool for a second pilot with provisional licensure? What would those numbers look like? So here are those numbers. Looking back 5 years, how many people would that be, including and then also excluding the people who were already qualified for the current expanded program? So it's 3,198.
Can I just ask a quick question about those numbers, Audrey?
You sure can.
So do those numbers include people who were eligible under the other one but did not choose to sign in or sign up for it?
Oh no, so they include the people how many more people would be added into that pool, but excluding the people who qualified. So I'd have to look, and maybe Amy, well, I have the people who applied on the last slide, right, and accepted, but I don't have that number right in front of me of that additional. That's a good question though. I know I probably have it somewhere. I don't have it in this slide.
Because I'm wondering if you sent out something saying, hey, we're doing this again, if it would be 1350 to X number, and it would wrap in those people who perhaps didn't take advantage of it the first time around. So it's actually a larger number.
I think, yeah, I would think if we did 1350 to 1439, inclusive of people who were eligible but did not take it, I think that would be the most fair way to do the new pilot. But that's all up for discussion. But thank you for the question, and thank you for speaking up since I can't see you. Okay, so moving quickly through this, another possible pathway, which we've obviously talked about a lot today, would be looking at what Oregon's doing with their Oregon state law schools, which is expanding experiential training in the California law schools. So would there be an exam at all? No, there'd be capstone projects. The scalability question, the supervisor question, the matching question, well, if it's all embedded in the law schools, then that's building on the existing law school infrastructure. Scalability, including resources, well, it would be different for what we do now. So we'd have to repurpose or have new resources because we'd be looking at additional curricular requirements. So drafting and applying and regulating those, and then creating rubrics and scoring a capstone, which is different, right, than an exam assessment. Consistency, how do we make sure it's consistently applied? Well, we could control for curricular consistency with experiential training requirements. The access and fairness question, if it's built into the law school infrastructure, it's as accessible and fair as accessibility into those law schools. Minimum competence, you would work on that through the design, right? So the review of curriculum, the additional requirements, the rubric that you create for what needs to be included in the capstone and the grading of the capstone, you'd work with that design to control for minimum competence. I anticipated this question, so I'm bringing up this slide of what's the makeup of the California law schools. Again, that same 20-year data. How many are ABA? How many are CBE, which is what we label them, but that's the California accredited. And how many applicants? And this again, it's all first-time takers. How many are California unaccredited but registered? So across time here, it's 87 to 90% of the applicants every year are from ABA law schools, 9 to 10% from our Cal accredited, and then about over time 3.5% from the unaccredited registered. Okay, again,
Just another quick question, sorry.
No, you're fine.
The ABA numbers do not include out-of-state applicants. They just include California.
This is California. Yeah, this is California. Okay, so looking at a third party. So if it's something like Lawyers for America or the Legal Services Funders Network, what would that kind of, again, that's a way we could kind of distill and maybe limit non-exam pathway based on interest and based on like a third party helping to administer. So would there be an exam? When we had LSFN present, it was sort of a maybe a mini exam, there'd be mid-year and final projects. That's obviously all up for design. Scalability and supervisors, well, these public interest law organizations are the ones matching the applicant with supervisor. Scalability in terms of our resources, again, new or repurposed resources to create this possible mini exam, to score mid-year and final projects again, and to calibrate and have rubrics, and then this oversight of the program and the supervisors. Consistency, we have the oversight by the state bar, the matching through the public interest orgs. I made a note to myself, which actually was interesting because Lynn had this with the Lawyers for America. Should there be some sort of commitment term? If you say your interest in public interest, have an interest in public interest law, and you get matched, should you have a year, 2 year, what would be your commitment term? I did Teach for America, and it was a 2-year commitment to teach in an under-resourced area, for example. Access and fairness, what's limited in scope and interest, so it's a smaller pool, and access to supervisors would be provided by the matching with the third party. Looking at minimum competence, we're looking at additional education requirements, the new attorney courses, and then maybe a mini exam to try to check all the boxes by design for minimum competence. Okay, so based on those numbers I presented a few slides back, there still are, a significant enough bucket of out-of-state law schools and that international JDs and attorneys. What do we do with that population? What the Oregon task force is looking at doing is an exam, so you could choose. You can choose the exam. For them, it's the UBE. For us, maybe it'll be a California exam or the UBE. Or you can do supervised practice and work product evaluation. So scalability in terms of supervisors, the applicant finds their own supervisor, so that onus is on the applicant. Scalability in terms of resources, so we would sort of, because the out-of-state population, the international population would have the choice, we'd be sort of doing as an organization 2 tracks. So we'd be administering an exam and a supervised practice program with the scoring, with the work product, with the calibration of that work product, and the oversight of program and supervisors. So potentially some degree of increase of resources. Consistency, again, you can try to control for consistency with the design of supervised practice and the work product. If the applicant is left to find their own supervisor, that's a similar issue with our provisional licensure program with the availability and quality, if the onus is on them to find a supervisor, but there's always the bar exam as a backup. Access and fairness, the inconsistent availability of supervisors is inequitable, but the bar exam is still a pathway, so there's still a way to be licensed, not just through supervised practice. Minimum competence, again, was based on our design, looking at all the different ways to look for minimum competence that we've learned about over time, the rubric for work product review and grading. And then, and this is sort of works hand in hand with sort of some of the conversations that the other subcommittee is working on, is what do we do with the population of attorneys from other US jurisdictions? If we do admission on motion, and with that, do we add a California exam or additional California law-based education in addition to admission on motion? There'd be no issue with supervised scalability. In terms of resources, if we have a California law-based mini exam, we'd have to design that, score it. And consistency, they've already passed a bar exam in another jurisdiction, and the California exam or education requirement, maybe it's again kind of modular like the prep program in Canada, that ensures consistency. It's equitable, it's open to those who are barred in other jurisdictions, and then the minimum competence they've passed the bar in another jurisdiction. Okay, and so I made this fun box, which is just a nice graphic. I hope it's a nice graphic, but it's pretty simple. Like looking at all those slides that I just shared, where is everything kind of going across the top? Like, how are we doing in PLL model, like I just described to you? Well, there is an exam, the scalability with the supervisor, because the onus is on the applicant, that's scalable because we just go out there and find a supervisor. The infrastructure exists, so we have the resource, we built it. It's not consistent, it's not across the board equitable. And then because there's a bar exam already, it does meet for minimum competence. And then looking again at the California Law School experiential training expanded model, there isn't an exam. It's built into law school, so the issues with supervisors would be, we don't need to worry that it's going to be an issue with scalability there. Resources, we can repurpose, the resources that we might have. Consistency, again, it's based on our design with law schools and trying to regulate these kind of additional new experiential training requirements. It's as accessible and fair as getting into the California law schools is. And then by design, looking at, that would be our burden, right? The design of the program to meet minimum competence. Looking at third party, had a lot of question marks because we're not sure, is there going to be an exam or not? And then yes, if the third party matches, then we're looking at a matching between supervisors and interests. What's the resource burden? That's kind of unknown. The consistency, a little unknown. It's equitable because it's a small enough number of people who are interested, and then there's going to be the matching, again, competence by design. And looking at supervised practice or the bar exam for out of state and international, one path is the exam. It's scalable because they find their own supervisor. Question mark for resources because it's kind of doubling some of the things we're already doing. Consistency, not sure. I put question mark plus, not sure on this and how that's going to work out in practice. Access and fairness, you do still have the bar exam, but it's not, if you wanted to do supervised practice and you can't find a supervisor, that's not equitable for that person. Again, competence by design. And then looking at admission on motion for out of state, for that, 5% or so every year, out of state attorneys who've already been barred in another US jurisdiction, they wouldn't need to take an exam unless we have some California law component. So there's a question mark there. And then a lot of the other things are check marks across the board because they've already sat the exam in another jurisdiction. So that's my very quick summary of what we've talked about. And now we're moving to group discussion and recommendation. And I can go back to any of my prior slides if that helps us as we move to the remaining time, which is still, we're good. We're pretty good, 3:37, to talk about what are we going to recommend. And I can, again, go back to any of the slides I showed.
Thank you so much, Audrey, for that detailed presentation. It looks like we do have a question starting with Mylon.
Yeah, thanks. That was really dense and well presented, Audrey. I think I'm gonna have to review those slides quite a bit. I have a million questions. The first one that came up for me is I think we have to talk about the scalability column in almost every one of those. And there's the scalability supervisors. And my first question is scalability resources. When you said that the bar built the infrastructure for the first and second round of the PLL program, what was that infrastructure, and how would that be able to absorb what were the numbers that I think we're talking about?
Well, two things. So the resources I was referring to would be staffing resources. And then we had to build out a whole different part of our database and tracking, right? To see where people were with their timesheets when they reached the 300 hours. And then working with another part of the organization with their first year attorney courses that they were taking. So making sure that everything we built in, we said were required, people were doing everything that was required. to finish that program. So that's what I meant. And we did that with the original pathway. And then with the expanded, we had to do more because there were more requirements. So we built that. And what I was talking about another, it would also be limited. So if we did something exactly like the provisional licensure model now, but maybe brought back the cut score to 1350, it's limited to that, well, 3,100 plus whoever might want to take up the program but didn't do the first round of expanded.
And
But
just out
Audrey, I
of
think-
curiosity, how many staff people was it and what was the cost, I guess?
Oh, Amy might have to give me a phone a friend on this one because we did have existing staff sort of pivot for part of their time. And then I know we brought on some temporary staff as well.
But I think part of the point that we need to get across on this is that the provisional licensure program was, I'd say, in terms of the supervision requirements, was not particularly rigorous by design, right? Because we were dealing with the pandemic situation. We've got people who just graduated from law school, really couldn't sit for the bar exam because of COVID situation, because they were uncomfortable taking a remote exam. People who were responsible, you know, financially, the sole financial responsibility for their family, needed to get to work, right? And as a result, the Supreme Court said, create a program that will help these people out. If we are talking about a permanent program, you know, my own personal observation is that, you know, you would need something that has a level of rigor that is unlike what the provisional licensure program had. And it really doesn't, frankly, represent a good model because it would need to be entirely different. The lack of consistency in the quality of supervisors, the fact that even with the level of rigor, some people did find it difficult to find supervisors, right? Having people on their own have to find supervisors just doesn't create, I think, a good model for something that we would be, if we would be trying to say, this is the path to bar licensure. You have to find your own supervisor. They could be of varying quality. It doesn't seem to create a strong model that would have the rigor that we'd want to be looking for if you're talking about something that is an alternative. It worked very well in the circumstances that we had, and because it was limited, right, to those people who scored between 1390 and 1439 on the bar exam in terms of those who had a pathway to admission without a subsequent bar exam. They, you know, had arguably demonstrated the minimum competence that we're asking people today to demonstrate by having that same 1390 passing score. But without that, sort of by itself, it doesn't feel like the kind of rigor that that we've all been sort of asking questions about with all of the presentations that we've had to date.
You can all just, if you have a question, if you could just speak up. And so instead of calling on you, I'll just let you.
I did want Amy, if you had some ballpark for Mylan on the resources, because now I know we had a couple temps and then we repurposed some of the staff time in eligibility. People who normally work with the bar exam.
I'm struggling with that because we had so many peaks and valleys, right? We implemented and designed simultaneously and borrowed from existing staff. So I'd say that in terms of the design stages,
we had a consultant come to our contractor come and work with our Salesforce program to build the whole program infrastructure. So Salesforce is how we do the back end database for our aims. And so we had a contractor come to build that with us. We had to test it for several, I would say months, but it seemed faster than that. It's probably more like a month. And then probably 2 to 3 staff members had to sort of pivot work, and we had 2 temps. I know that's not giving you a dollar amount, but that's my recollection.
And I'd say in terms of FTE, it might be something like between 2 and 3 FTEs total throughout the program and currently.
Thank you, Mila. Susan, did you have a question?
I thought Dr. Henderson was in the queue before me, but maybe he lowered his hand. Okay, I wanted to discuss a little bit before we close the door on the idea that finding your own supervisor is inequitable. I want to be careful to follow up on Donna's comments. I completely agree. The PLL was a one-time unique circumstance. I think it's really important to draw the distinctions that would be present if we were to do some different kind of pathway today. And in part, I'm thinking of a couple of very specific things. One thing that makes me push back against the idea that it's extremely inequitable is that I'm not sure it necessarily has to be by design, for the simple reason that law schools did not get a huge amount of inquiries for help. We kind of revved up for it and it didn't come. We thought students would be coming to us and saying, hey, I'm in that pool, please help me, I need a supervisor, and it didn't occur. Now, the other thing that happened was we were unable to get a list of which of our graduates, and I understand why, but we were not able to get that list of information and know who our grads were that were in that group. So we were unable to reach out to them to help them. But I can guarantee you this, if you make a pathway that law schools can be part of, supervision will not be a problem. We will make it happen because our grads will demand it. If I have gone to your law school and paid your tuition and there is a non-exam pathway, you must help me secure that supervisor and do those things. And we're in the business of doing that already because we do it for externships. We do it for private placements. We have infrastructure ready that could be adapted to do this in a more rigorous way. As Donna correctly points out, we're not talking about a pandemic emergency anymore.
Jackie, you're on mute.
Just wanted to speak to one piece of it. At my previous law school, which was ABA, we actually trained supervisors where our students went on externships. And so if we were going to use that, I would hope that the California Bar would have a supervisor training that someone would need to go through before they could take on any kind of PLL or whatever it ends up being. I think it also would instill in them the necessity of their supervision and final sign off as this person is minimally competent, and whatever that might look like in terms of our determination of that, because they're part of that gateway then. And so I think what we know about the attorneys in California is they're very protective of the profession. And so I think people who did that would take that seriously. I think right now students are paying at least $800 plus to sit for the bar exam once. I could imagine a fee associated with this supervised pathway program that could actually be used for that education and incentivizing attorneys to participate in a meaningful way in this. I do want to talk a little bit because I know we normally think of our applicants as just starting their careers. We do have a subset that are working adults who have mortgages and children and other responsibilities that would make it difficult for them to kind of leave work and work for free for an entire semester full time as part of school and as part of a supervision type thing. So I want to be conscious of that. I also do want to think about the prestige factor. I know some of our students did struggle to get supervisors in part because a Cal accredited law school has a reputation, fair or not. There are actually some law firms and government offices that will not hire unless you've been a graduate of an ABA law school, fair or not. So I think we do need to be conscious of the inequity that just exists in the legal profession generally that will have an adverse effect on some, as well as while it's not a big population, the population of working adults with responsibilities that would make it difficult for them to do some things that might be designed. And so I just wanted to bring those things to people's attention.
Thank you. And I think I had the oversight, but it was in terms of the supervisors, yes, that'll be part of the resources that we need too, is to have that oversight. And we heard that from some of the Canadian jurisdictions about how important it has been to go back and do more supervisor training. So I think that would be really important in our design as well.
Also, I think one of the ideas that was brought up today is the MOU. A few of you raised the MOUs that exist between applicant and the supervisor, and I think that it would be a very beneficial aspect of the program.
I've been listening very carefully, at least as carefully as I can. And I think we need to assess these pathways, if you will, separately, right? Because we've talked a lot today about the law school experiential pathway, and I have thoughts about that. And there's hybrids of ways to proceed that could be very palatable to the state bar, at least in my mind. Then there's the pathway for people who for generations have been excluded because they haven't met the cut score, but are no longer in law school, but perhaps need a paying pathway to become a licensed practitioner. And then there's the pathway of everybody who wants to practice in California, but can't because we have these, I'm gonna use the word arcane rules associated with reciprocity. So maybe if we focus on one, we could come to some, get some discussion points where we're focused. And I appreciate what how Audrey summarized the presentations to date. And I think there are solutions there for all of those. And I'd like to hear some discussion about it. I have my thoughts, but I'd like to hear what other people think.
Yeah, I think, Judge, that was the right way to, the exact right question to ask, because one of the things that we had talked about at a staff level was if you're looking at numbers, it would seem like the pathway that we need to talk about sort of first and foremost is those coming out of California law schools, because that's the majority of the numbers. And if this subcommittee, if this committee recommends that we adopt one of these paths for people coming out of law school, we need to just be able to say, yeah, and we think we can develop a path that would account for other people. Like, I don't think we can tackle all of it today, but understanding like the biggest group, if this committee can come to a conclusion on a pathway that makes sense and just sort of say, yeah, we think there's room to figure out what we could do for other people who are coming to this question, not immediately as law school graduates or in law school.
And so I agree with that, Donna. And so with respect to the law school experiential pathway, of which there's a lot of people with a vested interest, at least in this particular subcommittee, the discussion seems to be curriculum based, really, because everyone keeps coming back to the fact that people take classes in law school because they need to pass the bar. But really, the law schools should be the places where our students learn the core subjects, right? Contracts, torts, real property, constitutional law. And the law schools should be the clearinghouse for those folks. And if they pass, why do we spend our lives focused on, funding Barbary for purposes of an omnibus exam after several years? It doesn't have any logical sense to me in light of the practice of law. And so and I was listening to Jackie, and I was listening to Susan, and so Jackie said that 57 out of 84 of her students' units are devoted to law school, to the typical bar exam subjects. And Susan said it was slightly less. I calculated Jackie's as 67.85%. And Susan's as somewhere between 61 and 65%, depending on which numbers you used. And so really, 2 out of the 3 years of law school are being devoted to core classes, which should be the principal purpose of law school, in addition to some practical training. And so why can't an experiential pathway involve the first 2 years of law school being totally those core classes, and you pass them, And then the third year would be 100% experiential for those people who don't want to take a bar exam, right? So that they are segued to a point where either they're ready to practice law, or perhaps more palatably to the California practitioners, maybe they need a single year of what I'll call residency as a California practitioner, where they can appear in court, they can write lawyer letters, all under supervision that we've talked about with certain supervisory limitations. But you know, they've done the experiential pathway, they've taken a full year in law school to learn these topics and to clinically participate in the topics, and then practice it for a year. That would seem to be, I think, a lesser revolutionary move than Oregon has is talking about, and certainly the New Hampshire type program that we talked about earlier. So to me, if we talk about an experiential pathway and we want to make it work for our existing practitioners in California, and we want to negate all of the negatives of people going, of the law school experience being so bar focused, that might be a nice segue, because there would really be no difference between a resident attorney and a full and a permanent California attorney other than the 1 year supervision. So that's kind of what I'm hearing and what I'm thinking, but that's just, you know, one old retired judge thinking about it.
Amy and then Jackie.
I tend to agree with Judge Glenn. I think for me, it's almost similar to medical school, where the first 2 years are strict instruction, classroom instruction, and the last 2 years are more of a practical application of what they've learned. They're in the actual clinics, they're in the hospitals, they're doing things that are not in the classroom. So I can definitely see a non-exam pathway encompassing a more practical environment for these students. Again, I just want to reiterate, it's the amount of time and the frequency that's concerning me.
Jackie.
Yeah, thank you. And Judge, thanks so much for articulating that. I think a couple things jump to mind when you talk about content. Right now in law school, content is king. If you were to tell a particular professor that they needed to cut down or do something different, they're worried that it's going to be covered on the bar exam. So I want to make a distinction between foundational knowledge for practice versus foundational knowledge for the bar exam, because I think they're two different things and we need to think about them differently. I think if we're talking about those core courses, that kind of laying that foundation of what we hope any law student will graduate law school with a basic understanding of, what we want is foundational knowledge and FAR transfer. When you're thinking about kind of, especially knowledge in right now, it's doubling like every 12 months. It's not possible to teach things as a static subject. So what we actually want to teach them is foundational concepts, including those broad things like critical thinking that can then result in FAR transfer when they get out to practice and are facing something completely different and unknown to them, which we all know does happen and will continue to happen. So I would structure a curriculum very differently with foundational knowledge like you're talking about leading to practice. I would disengage it from final exams and instead insert some of those practice-oriented things that we're talking about directly into the experience of torts, directly into the experience of civil procedure, rather than worrying about them taking that final summative exam that is equal or similar to the bar exam. So I'm all for laying a foundation followed by the ability to put it into practice. And then even tying it to something that has a supervised practice that has a state bar kind of stamp of approval on it beyond our curriculum. But just taking away the bar exam would even change how we teach those core foundational subjects and what we focus on when we teach it and where we place our emphasis. They don't need to know everything about torts, but boy, do they need to understand how it plays out and where it might come up, and be able to take those concepts and transfer it later down the line. So I believe and accept everything you're saying, and Amy, rigor is equally as important. We need to define what that looks like. But I think core foundational knowledge plus practice opportunities is an absolutely great way to begin this conversation.
Donna.
So I'm gonna start by saying the same thing that Amy said, which is at the start of this commission, I never thought I would have been arguing at all about in favor of a non-exam pathway. But I've really found a lot of these conversations incredibly interesting and informative. And sort of taking what Judge Reeser had suggested as sort of, one of the approaches, right? You've got some amount of time, right? I don't know what the right number is, but some amount of time on these core foundational topics. And I really like the way that that Jackie and Andrea talked about, weaving in the skills and the experiential learning in all of that coursework, and the way Jackie just talked about it now with, she'd have products that are related to torts, not a year-end summative exam. And then sort of taking into account what Jackie said and the program that Susan was describing that is offered at Loyola, where you are acknowledging that there are students who can't do a full-time externship because they are already working at a job that they need to get that income from, or they have family obligations, providing sort of the different options of simulations, the practica, the clinics, the different ways that you can get that experiential knowledge. Susan, I don't think I will ever want to participate in your sales and use tax clinic, but that aside, just sort of having that kind of opportunities. And I when I think about scalability, I think about access, I think about cost as part of access for the students. It seems of the many models that we've talked about, a model that is based in the law school would lend itself best in my sort of, based on what I've heard, to answering some of those questions, right? Having a curriculum which would have to, be developed in part in, there would be some state bar oversight of the curriculum and the supervisors for experiential training, and we could apply those same requirements and rules to a law office study program and the supervisors in a law office study program, just trying to sort of figure out how to put all this together. And then you've got students who don't have to pay for Barbary, aren't paying for the the exam, all of those things that are related, the X number of months that they're doing nothing while they're studying for the exam. There's some real interesting opportunities for a non-exam pathway that I think when we put together all of these discussions at the prep program from Canada, create some real opportunities to create the rigor that I think is necessary to ensure minimum competence, and that the use of the law schools and their curricula really can help with the consistency and scalability, I would think.
Susan?
I just wanted to follow up on a point that I think Mylyn started earlier when she said she teaches evidence, and what Jackie said today. And I also agree with Judge Reeser that it is important the students have those basics. And I think the disagreement for those of us on the ground in the law schools is that distinction between what the bar exam tests for those basics and what a lot of us would define as the basics necessary for practice. I, like Mylyn, have also taught bar courses. I teach remedies. I have in the past taught ethics. I have in the past taught California civil procedure. And there is a constant strain between what I want to teach to get them ready for practice. For example, in remedies, the students love to have me tell them, you have to, what are the bond requirements when you win an injunction? Extremely practical and will keep you from looking like a rookie when you win. Contrasted with the bar exam is far more likely to test an antiquated common law defense that nobody really ever uses. And yet I'm faced with making choices every day in my class. Which of those am I going to cover? And I do think that we have an opportunity here to really rethink legal education and licensure in a way that does it all, that really lets us integrate practice into our teaching and into law school in a much more structured way, rigorous way, and consistent way, so that it can be part of that licensure path somehow in some way.
Go ahead.
So I did raise my hand a little while ago, Susan. Thank you for honoring that, but I did also lower it. I just wanted to take a little more time and think through everything that I've heard. And I guess, you know, there are measurement principles that would have to apply to these authentic assessments that would be the outcome assessment for all of this. Issues around comparability for the things that every student does, every candidate for the bar examination does, and comparability in their evaluation. These things are really very much core to the fairness of the summative assessment of whether or not an individual gets a license to practice law in California. What I've heard in all of the presentations is a lot of freedom given to students as well as to faculty and program designers to decide what is going to be covered in all of the different options that we've looked at, and what's going to be covered for any individual or group of students coming through. And I'm concerned that when at the end of the day, the evaluation of outcomes and a decision about the sufficiency of a person's proficiency in law is made, that it has to address the principles and psychometric requirements that be able to support demonstration of reliability and fairness, and with a passing standard that is criterion referenced and applied to everyone in the same way. These things can be done. It all can be done. I'm just worried that, I mean, the way, the tension between teaching law and the bar exam and the assessment of proficiency in today's meeting was really tense. And I'm worried that that you might not get the freedom that you think you're going to get when you introduce an authentic process like this into the mix. You may not get the freedom that you want to have with it. So anyway, I have more questions now than I did before, but you know, there is, I think, a pathway that can be found. Maybe it's the foundational courses followed by the experiential, but remember, in medical school, because that was brought up. That is sort of the model for medical school. But at the end of that, there is the USMLE. So, I think that the model is a good model. I caution us not to overemphasize the teaching of law when licensure depends on an assessment of proficiency that is fair and for which the fairness can be documented. So anyway, that's what have more questions than answers, but that's what I had to say. Thanks for letting me.
Jackie and then Mylin.
Yeah, and Dr. Henderson, that has been my question all along. How do we establish that kind of validity, reliability piece that is so essential to any kind of licensing procedure? I think why I'm not bothered by the idea of being more limited is because anything, hopefully, that we would create would be directly tied to the practice of law. And so our bringing it to the students wouldn't be a tension between, I need to teach you about X because it's probably going to be on the bar exam, but you're probably never going to run into it in practice, or it's not relevant in California, but it might be on the MBE. So I think absolutely understand that we need to create that. When it comes to that kind of creating I don't know what the authentic assessment from the outside. I know that Western governors and their competency-based education has worked incredibly hard to create sophisticated assessment tools for their competency-based education. And I don't know whether, Dr. Henderson, you've looked at kind of the assessment tools in educational contexts like CBE to see whether or not it would be transferable to something that we're doing on the licensing side.
Mylin?
I wasn't sure whether Dr. Henderson was going to respond. And as usual, I raised my hand and then somebody asked a better question than mine. My question was actually whether I'm with you, Dr. Henderson. I understand the importance of outcomes and assessment. And all of teaching should be geared toward the correct outcomes and the correct assessment methods. And I latched on when you said it can be done. And I wonder whether you could expand on that a little bit, either by responding to Jackie's more pointed question, whether you've looked at those materials, or like give me a glimmer of hope here. How can we have both, right? Some method of assessing real attorney competence that is valid, reliable, consistent, et cetera, all the things that you've brought up all along, but that isn't just measuring what I now teach, which is this is how you IRAC an evidence exam with a 1-paragraph fact pattern. Here's your first heading, underline it, bold it, because the reader wants it to be underlined and bold. Here's the definition of relevance, spit that out on the page.
Right.
That's not outcome, or that's not the right approach either.
So there is the practice analysis. The CAPA project did go through a deep analysis of practice, very systematic analysis of practice, and has identified the foundation that I think authentic assessments as well as objectively scored assessments can be based on to ensure the proficiency or the ability of a person to practice law in California. Jackie, I don't know the materials that you're talking about, but I'm happy to read, and I'll make it a point to follow up with you. And do that. But I think that so this authentic assessment, performance assessments, all come through a process that is not unlike what was articulated at the outset of the commission meetings with the different stages of test development and the principles that are followed. But there are a few things. Basis in practice, and that is defined through practice analysis. It is. That doesn't mean that the kinds of things that would go on in a law school internship or externship are limited to that, but the practice analysis has to supply the floor. And then components of the program that where data can be collected in a formative way through the practical experience itself and feedback given, so that the programs are broad across the practice of law. The license does allow a person to practice anything. If this experience is too limited and too focused, then that's not in the state's interest, that's not in the public's interest. The comparability in challenge is really important because if a person is unsuccessful in achieving the license and can defend a claim that the course of study that he or she completed was, or the assessment of that course of study was more rigorous than others, then that leaves us open to vulnerability. And then what that standard, the procedure for setting the standard and documenting that it is comparable to whatever the standard is for any other bar exam that might be used in California. All of those things are critical, plus reliability. And you're getting at the reliability by training the supervisors and giving them the criteria that we need them to use statewide. And then, you know, that can lead somehow to a capstone project or something like that with a rubric that can be scored centrally. I feel like there is a pathway through this, but you know, there are stones and gotchas all the way through. But yeah, I mean, it's a doable thing. It's just, you know, money, time, and constant vigilance in its implementation.
Dr. Henderson, listening to you and your explanation just now, I've been thinking whether, and I'd like your thoughts on what your views would be if this were limited to developing some type of curriculum, whether it was what Judge Rice was saying about foundational skills combined with experiential component to it, but doing some type of pilot of it, working in conjunction with a number of schools, a smaller number than just developing something that would be broadly distributed to everybody initially, instead limiting it and then looking at it and seeing what type of data we can come up with to assess whether it is reliable, the concerns that you're articulating. We might have more concrete information if it's a more limited pilot project. I'd be interested in your thoughts on that.
Absolutely. I think that a lot of time and energy would have to go into each component of the program and piloting each one separately and then the program as a whole before it's rolled out. But I do think that collecting data along the way so that it can be used formatively in the design of the program and the assessment, the aspects of it at the end. Absolutely critical.
And then
I
on,
apologize if my dog is coming through. I work from home and she's downstairs. It's dinner time.
that's okay. And then from the school's perspectives, would there be an interest? I imagine there would be schools that would be very interested in participating in that type of a pilot project, but I may be wrong.
Obviously, I am not the dean of my institution, so I cannot say yes, but I will tell you that this is something schools are interested in because a lot of us, I think, are willing to do all this heavy lifting. I think we have much more agreement than we have disagreement in terms of balancing all these concerns. None of us that want a non-exam path don't realize it will be an uphill battle and extremely difficult to execute the nuts and bolts. The devil is in the details for sure. And assessing these things and getting that rigor and that consistency are major concerns. Despite that, law schools have made huge turns in diversity, equity, inclusion. We want to make a bigger difference there. And one of the things we need to do that is have an alternative to the bar exam. And so I do think you will have schools in with their hands in the air to do these things simply because it will help a certain portion of their grads that face difficulties with that exam. It creates access that is better. And I think schools are willing to put in the hard work for the long run potential. And I think it's what a lot of us, and I'll speak for myself, in particular on this commission, feel strongly in favor of a non-exam alternative. It is because we feel the California bar exam is so deeply flawed and is not furthering the interests of California. And we worry about the rigor and the consistency here, where right now someone can pass the California bar exam with almost no experience and be entitled to practice.
So of course I can't speak for my law school. I'm a lowly clinical professor, but what strikes me is that it is so worthwhile and so much work. The difference between how many resources it takes on my part as a faculty member to teach my large evidence class, as opposed to my clinic where I supervise only 6 students, and to develop those assessment tools that Dr. Henderson is talking about. That's, I mean, the resources that go into experiential learning are significant in comparison to teaching a flat doctrinal class. And I think any member of any law school administration will be very, very conscious of that, and perhaps resistant to some kind of unfunded mandate that we, even if it's a pilot program, I think I suspect, and I would really push for it, Hastings would be thrilled to be a member of any pilot program. We're, way into the bar stuff to begin with. This would be right up our alley. I would love it. That said, as I'm listening to the different types of experiential learning and what the ways this could roll out, the easiest low-hanging fruit is really to have it on external supervisors, right? People who are not part of the law school. And then when I can't remember which where this came up, but the concept of part of your getting your license is your supervisor out there in the world signing a letter saying, yeah, this person deserves a law license. That seemed a little nuts to me, because the pressure on that supervising attorney who's been working closely with this person who they think is terrific. It's hard enough to give somebody a bad grade in law school anonymously. Imagine having no one would want to do it. So the low-hanging easy way to do it, and we run a few trainings for supervising attorneys, that's easy, that's few resources, but it's not the rigor that we're looking for. So again, I think there are law schools out there. I would push my law school. I would want to participate in such a pilot project, but people would have to be given incentives to do it.
I can speak for my law school. I would be excited to pilot something like this. I think, and this goes back to the outcome piece. What we want to do is have the graduates be able to meet certain outcomes. How they reach those outcomes, whether it's through a clinic experience, an externship, practica, or other types of things, I think hopefully has some flexibility built in depending upon where people come out. And the goal is the outcome. I too would, and I don't know, again, Dr. Henderson, I think we'll be relying on you, but to think about, and not the law school and not a supervisor who works closely, but an objective view of a portfolio or the student's work or an other way, so that there is a triangulation, the law school saying, hey, this is someone who performed well. The supervisor says, hey, this is someone who performed well. And then an objective assessment says, yes, this person meets those basic things. So I wouldn't want that to come just from one place, but I think we can triangulate the assessment piece so that there's multiple people who are signing off on particular areas of competence.
Yeah, and I would note that that's along the lines of what Oregon is doing, where the Committee of Bar Examiners equivalent, or in our case, right, the bar exam graders or people with sort of different skills potentially could be the ones who are grading, which gives you the ability to also be a check on the curriculum that the law schools are providing, right? If the law school has advanced the person to this stage and the graders are looking at this capstone project or, you know, a variety of written work across, you know, across the years, then that is sort of a view into what the law school is doing. The point I actually raised my hand for was just an observation that that if this is done as a pilot, it would have to be, I think, an incredibly long pilot period, because presumably if you're changing the foundational education the law school is giving, that starts in the first year, right? So you've got to have 3 years of what the new law school education and experiential training in law school looks like. Then if there is a year after potentially of supervised work beyond law school, as Judge Reeser originally said, you have to evaluate the pilot project. And then if you decide to not continue the pilot project, then everybody who's going through the law school, right, you have to basically teach out everybody who's being taught in this new curriculum to give the law school time to start teaching toward the bar exam again. So I think it would have to be a fairly lengthy pilot. Not that sort of weighs one way or another. I just wanted to make that observation.
Better a long pilot than a really horrible rollout of something that is flawed.
I was just going to mention something that is in the Oregon Task Force report in terms of the capstone. Something they mention is that the capstone could be a capstone project with a rubric or it could be the creation of performance tests using case files in a limited universe of material. So instead of having just one performance test, it would be some, like, I don't know, 4 or 5 where you get the case files. And so maybe that would get more to what you were talking about, Dr. Henderson, versus a capstone where we could have some sort of performance test in those universe of files. So it's basically like an open book, but performance test experience. Just a thought.
There are a lot of different ways that it can be set up, and probably, I mean, it's enough to know that there are a lot of different ways you can go about it. At this point, I think.
So, and I think when we were talking about scalability, sort of this question was embedded in there, right? Is it something that's offered at some subset of law schools? Is it a pilot? Sort of how is this structured? And I'm curious if folks are sort of leaning toward the notion of a pilot, what would be is it just law schools that want to volunteer? Is it a limitation on law school type? Is it law schools that have particularly well-developed programs today as assessed by an objective observer? Sort of how would that selection process happen? How would we sort of determine who's in the pilot?
No, that's partly at least a political question, but there's got to be science behind the design of the pilot, because you're going to need to generalize from the pilot study findings statewide to the population of all graduates from law school seeking licensure to admission, seeking admission to the bar. So I think that while there might be some aspect of a pilot that would call for volunteers, there would have to be a sampling strategy to make sure that you can reasonably and fairly generalize from the findings of the study to the population of concern.
And it would create a marketing imbalance, obviously, right? Because if one law student one law school is offering this program, and the world will know about it, and they will, their enrollment applications are going to go up about 3,000%.
Susan, did you have your hand raised?
I just wanted to sort of echo that point. And I think it's easy to assume that because I'm at an ABA school that I would think, well, we'll just pilot it at ABA schools, and I don't. I think it would be really important to have a school like Ventura and Santa Barbara in the pool, because I would want to see that kind of diversity so that we could show the kind of sampling that we need, and also to avoid the very real problem of schools are not going to be able to be allowed to choose who goes into this program, or it will rapidly not become an access program at all. And it'll become where everybody puts their highest and best performers, and that's not what we're after. So I think it's important that we think about criteria, and we think about, of course, having some existing structure in place like we saw today is helpful to choosing either a pilot or volunteer schools or some combination thereof. But I do hope that there are strict standards and requirements, and that we can create some level of fairness and ensuring that this will actually be an access program.
I think at this point it's quite reasonable to think that the commission or the court or whoever would be doing it at the state bar would develop a pilot program to explore and learn and test out everything. At this point, though, we need to know what it is before you can get too much detail around what the pilot study is going to look like. You have to know what the program is going to look like. And so there's an ocean of detail that needs to be fleshed out before any design and discussion really is beneficial on what the design of a pilot study would look like, I think.
Yeah, I think that is the key issue of moving forward and determining what the basic parameters of what it is that we would be recommending to the larger Blue Ribbon Commission. How to get there in 27 minutes is a challenge.
Well, it seems we've been talking primarily in this part of the agenda about a program that's built in the law schools. And so I'd certainly be curious if anybody is thinking about one of the other alternatives that Audrey had described when she was summing up what some of the other alternative pathways are, or are we coalescing around that such a program really would be law school driven?
Well, going back to what I was suggesting before, I mean, I've thought about all three, right? So I'm going to take would somebody use the term lowest hanging fruit first, would be the out-of-state attorneys, right? To me, my personal opinion is that if somebody has a demonstrable full-time practice in a different jurisdiction without any ethical violations, whether that's 5 years, whether that's 4 years, whether that's a long time like 6 years, they should be admitted because they're lawyers and they've been practicing law. They know how to do it. And I don't think we should run the state bar as a trade guild. I think we should be open to others with the expectation, certainly not the requirement, that they would also do the right thing and admit our practitioners. It's not a localized practice anymore. California is not an island. As I mentioned the first day, the lawyers I've seen from out of state are all competent. So why exclude them? It's the middle piece, the historic law school graduates who haven't hit the cut score over the last 40 years, 50 years, 60 years, that is more of a difficult concept because there's opportunity there, I think, without engaging in the psychometrics, to advance certain needs in California. For example, if the need is public interest, why could we not have folks who have a law school degree, who've taken the core classes, to then do, what did Audrey call it? The class they had in Canada, that intensive class where people learn, the 6-week, gotta go learn how to interview a client class, and then have them work for 2 years in public interest, right? And they're going to be paid. But if they do that, they've taken the course on how to practice law. They've taken the core classes in law school, whenever that was, and they've been practicing law effectively as a lawyer, resident, if you will, for 2 years. And then if they need a portfolio, fine, if that's the criteria. But there should be that opportunity for, I think, literally generations of people who've been excluded. And so I come at it from the antithesis of Dr. Henderson, who I love because we were on the last committee together as well, because he comes at it from a very quantitative and less qualitative. I come from a very qualitative, less quantitative perception. But then I've been a trust judge for years, right? And it's all about equity and good conscience. So to me, we can solve multiple problems by trying to create some niche where people who've been disserved by the bar, arguably for a long time, can be included if they take a certain path that helps, I don't know if you want to call it public interest, but the areas in which there are underserved communities and underserved populations that need help, right? Why would we not want to solve these problems? And they're not going to be terrible lawyers if they meet the criteria that we set up. And I know that's not a 20-minute discussion, Justice Guerrero.
But in terms of a pilot, and when Legal Services Funders Network presented, they talk about the pilot being open to all California law schools. So it could possibly meet more than just the need of limiting the pilot. Jackie, sorry. You're on mute again.
They didn't open it up to all California law schools. I hope they will. They did ABA only at the time that they piloted it originally. So I do want to.
Oh, you mean the Bay Area,
Yeah.
how it is for PTLS?
Yeah.
Okay, right, but.
Yeah, so back to the question about driven by the law schools, or I guess I didn't see it, I see it as a both and, because I see licensing obviously having a regulatory home in the Supreme Court of California with the State Bar partnership. So I see it as a partnership, that there would be a curriculum and core competencies that would be understood, that needed to be, they needed to be exposed to and have the opportunity to practice and show some competency in while they're in law school. But then there would be an external piece, whatever that might look like, in cooperation with the State Bar and the Supreme Court in terms of what they might determine. So I never thought of it necessarily as simply I've graduated from law school and therefore I can now practice law, which would look more like diploma privilege, but more, even if it's just a practice component once they exit for 6 months or however many hours with supervisors that have been trained, and perhaps another external assessor on portfolio or whatever the case may be. But I really did see it as a partnership and not just a law school kind of pathway.
Thoughts on how that approach might work for people who go to out-of-state law schools? So not the people who've been practicing attorneys for X number of years in other states, but somebody who went to an out-of-state law school and wants to immediately, right, they would have come to California to take the bar exam. Instead, is there a path for them in this scenario for entry?
Susan?
I think that was part of the Oregon model, right? Is the Oregon model suggests that there would be a supervised path available to out-of-state graduates as well. And even though I'm from an ABA school, I hope we wouldn't draw that easy line. I don't think that's a good choice, and probably not one we should make for a lot of reasons. But I would also like to hope that we could try to focus on our own grads first as the biggest group, right? Like the students who are in California law schools today at an ABA or a California accredited school, and move toward some kind of pilot that suggests we can move away from a bar exam and have a bar exam as an alternative, but no longer the exclusive path to licensure. And I think that if we could narrow our focus and then acknowledge that after a pilot, we would find solutions for out-of-state lawyers, out-of-state grads, or that the exam alternative remains the solution for that until the pilot can be established. But I think we should, California's always been a state that's a leader, and that's been my mantra and why I wanted on this commission from the beginning. We should lead, we should be bold, and we should do it for our own grads first.
And that's right about the Oregon, a supervised practice or the UBE. So it depends. So they could do both if they didn't want to secure a supervisor. Well, I've heard Judge Reiser talking about the third party, the public interest pilot as a viable pilot. I'm not sure where we're landing with other ideas of a pilot. If it's helpful to go through any of the slides again, or I'm not sure if I want to put everybody on the spot and making you vote, but where you might be if you're comfortable expressing a feeling for a recommendation on one of the different pathways, that would be helpful. Susan again.
I don't want to monopolize time, but I have thought about a lot of these things for an awfully long time. So perhaps for some of us, this is not something we just heard about today. One of the things I feel strongly about is I'm wide open on a pilot and what we would do to try to get started, and how we would do that. But I feel strongly it should not be limited to public interest. And it's obviously not that I have any disfavor for public interest. It's important and compelling work, but it's a very limited piece of work. It doesn't pay very well. And as Mylyn pointed out, sometimes those fellowship programs do not always attract the most diverse group of folks that are capable of doing it. And I would hate to see us pilot something so very narrow. And so I hope that while the public interest programs provide us with great ideas, structures, and lessons to learn, both things not to do and things to do, I would hope that we would not limit ourselves in that way.
Thank you.
I would hate to see the result of this committee, because I agree with you 100%, Susan, that California is a leader, right? But really, Oregon is the leader, and what you're suggesting as well, only on the law school piece, we'll have this pilot program of only certain folks that Donna has articulated would have to be rolled out over a course of years. It doesn't solve. It may solve the problem. I mean, outnumbered on this committee by law school people, and that's fine. But I think there's a bigger set of issues in California, and that is the legitimacy of the bar exam. And it's not just.
I didn't mean to suggest that I preferred the narrow pilot. I do not.
Okay,
Just
I'm
that
sorry.
I would support it. Let me just clear that up.
Mylyn?
I think I raised my hand because just to clarify my position in the sense of why my tiny program has turned into a not so diverse program. It's primarily the pressure of the concerns about the current bar exam. There are some studies out there that students of color want to go into public interest when it's possible, at greater rates, higher rates than white students. So I don't know, I know what you mean, Susan, that somebody who has a trust fund is going to be able to take a public interest position in a way that somebody who doesn't can't. Absolutely, but I don't think that by focusing on, perhaps even limiting to public interest options, I don't know that we would categorically end up with a less inclusive pool. And I, for one, again, just speaking from my own perspective, I do want to address some other problems that we have with the delivery of legal services in California, which is that people who are low or even moderate income cannot afford legal services anymore. And if we can chip away even a little at that, I would like to kill two birds with one stone. And I seem to be like the metaphor queen today. So I'll mute myself before I go too far.
Maybe Josh and then Jackie.
Yeah, thanks, Audrey. I try not to participate too much. I don't know what my role on a subcommittee is as vice chair, and I don't think I'm a voting member coming out of recommendations. But I do think that it's important, as I've listened to all of this, in coming up with a pilot, we've removed a couple of the major issues that we were concerned about, scalability being one of them, right? And talking about whether that's supervision or resources. I think a pilot would really need to focus on minimum competence and consistency. And if those were the things we were focusing on, I think the only way it would be successful would be to have a broader group of people. If we narrow it, I think it's going to be a lot harder to come out with any kind of results in the end and findings and path forward. So I do think breadth would be important and really focusing on the consistency portion.
Jackie, your hand's still up, I imagine. You're on mute again. I would do it if I could. I'd unmute you.
So just in terms of voting, and I think for me, well, one, broadly in favor of the non-exam pathway. I know I've kept that very close to the vest and you guys are surprised by that statement. I'm excited by the idea of being able to craft something that is meaningful, both in the continuum from law school into practice, and can really prepare students. So it excites me to think that we might be able to do that. I would love, as Judge Reeser would, to rip the Band-Aid off and say, let's do it, and wonder if there's a way to bridge between like a PLL program with a little bit more rigor to start out, followed by a much more established and objectively assessed program as the ultimate outcome. It would allow us to deal with the concerns that everyone has about the bar exam and its effects, and create a bridge to a program that's going to be more meaningful in the ways that I know we need to build for that public protection and competency piece. So I recognize that that might not be an acceptable position for everyone. So for my plan B, I think what worries me about the pilot program is not the pilot program as an idea, but more choosing who gets to be in it. Because I think that's going to be a challenge. I think you might get a lot of law schools and certainly a lot of law students who would be very interested in having this opportunity presented to them. I think it would be very challenging for the state bar to say, the students in this school get that opportunity and the students in this school do not. I'm not sure that that's equitable or fair. And I think we should think carefully about what it means to have a pilot program and how we choose who gets to participate, because it really is, for some students, it might be the only way they're ever going to get a license to practice law. And to shut them out of that and say, no, you still have to do the bar exam is troubling to me on several levels. So I just said a lot. So vote, top alternative is to rip the Band-Aid off and really try to figure out how to move forward without an exam, and recognize we need both a short-term and a long-term solution. And then secondary, a pilot program with all the caveats that I said, because I don't know how you would shut people out of that in a way that doesn't feel inequitable.
I just want to add that, this discussion reminds me a lot of our discussions when we were coming up with the provisionally licensed lawyer program. I think a lot of the themes are the same about consistency, equity, and so on. And that took months, to develop. It took a lot of conversation, a lot of engagement. I'm thinking for this next round, it sounds like we know the direction, or at least there seems to be a little agreement on a pathway or an alternative pathway. But what we have to build and establish is the design of it itself, right? I mean, I think everybody's in agreement that the pathway needs to be equitable, that there needs to be an assessment, right, that's consistent. I think that the summative assessment that we talked about that allows for comparability of every participant. Susan, earlier in your presentation, you talked about the use of simulation. And I think a simulation could be one of those ways of creating this fair assessment as well, like at the post stage of any type of apprenticeship as part of this, is if that's what we want to do. So I just think that there's a lot of potentials that we've talked about. I think we're getting stuck on the technicalities of what this program should include, but there was a lot that was shared today. I think that is promising. So maybe what we should be looking at is whether there's even consensus on the pathway rather than what this design features or what needs to be incorporated in that. It's just as an idea, because I know how long it took for us to do PLL, and I think we're trying to do that in like 10 minutes today. So just a thought.
Mylin?
Should we be thinking at all about not like pie in the sky, what we think would be absolutely best, but what's going to be palatable to later decision makers? Because I don't know how to assess that, and I'm not sure whether we're supposed to consider that.
The future audiences for this recommendation, you mean?
Yes.
I think we're all thinking that's a good point. Susan?
I have sort of a related sort of follow-up point, which is a procedural one. It's not clear to me. It seems to me it's a little bit of a chicken and an egg problem. It is the commission's purpose to actually put forth the entire specifics, or is it the commission's purpose to put forth, we want a non-exam alternative, and we've thought about a lot of things that would be involved in that, or is our obligation to actually present the path?
Yeah, I think that's a great question, Susan, and I think they're both great questions. I think that there are a couple of ways to do it, because I think the notion was that this commission would ultimately come up with, what does the path look like, right? Whether that's, what does the exam look like? What is this non exam pathway look like, right? It's really spelling it out. But what might, and this sort of goes to Mylan's point a little bit, one of the things that that the commission might want to do is an interim report, if you will, an interim recommendation to get feedback from the Board of Trustees and from the Supreme Court, is the ultimate sort of arbiter of this. If this committee recommends to the full Blue Ribbon Commission that we do an exam, a non-exam pathway, and that ultimately, right, so using Jackie's, let's do a non-pilot, right, not a rip the Band-Aid off, open this up to everybody. Commission says, yes, we want to recommend that. You know, before we go too far down the path of developing what the curriculum would look like in the law schools, I could see us doing an interim recommendation to the Supreme Court, ensuring that the Supreme Court wants us to continue that work. Neil, does that sort of approach make sense, so we can get that feedback from the court?
That would be one approach, but to be honest, you know, the more specific we can hear about what this alternative pathway would look like, the more likely the court would have, oh, okay, I can see that this has a potential, right? So I still think some basic questions need to be answered first about what that pathway looks like.
Justice Guerrero, is this supposed to be our last meeting, or are we?
No, we have other meetings, but right now, well, we can talk about it, but we had anticipated that we would report back to the larger commission after today's subcommittee meetings and tomorrow's subcommittee meetings, and then, you know, present to the larger commission just maybe general topics of what we've concluded. Yes, that there is a desire to pursue an alternative pathway, a non-exam pathway, and we've thought about possibilities of what that might look like, including experiential, I can never say that, a component where there is possibly supervised training, and so we can talk to them and report to them. I think a overview of what we've discussed, and possibly, you know, the idea of a pilot versus a broader program. And it would be helpful, I think, though, if we could give them, instead of just an overview of what we've discussed, some recommendations as to where we have a consensus of how to proceed. But if your question was whether this was our last subcommittee meeting, that was what we had intended, to then go back to the larger commission meetings.
So because to accomplish what Neil proposes, which I think makes the most sense, it's going to take some
more time.
Work.
Yeah.
Right.
Yeah, well, and ultimately, depending on what each of the committees recommends, then when we get together as a full commission, it may be that we go back to the same exact subcommittees, or it may be that different subcommittees are called for. right? So if everyone says, nope, we should only be pursuing a non-exam pathway, then we could have different subcommittees than we have today about what would that look like. If we are looking at pursuing two different pathways, then potentially we could have the same subcommittee, but same breakdown. But certainly having the taking this to the full commission and get the commission's recommendation. I certainly don't want to put words in anybody's mouth, but if you want to sort of take a starting point, it seems like Jackie sort of phrased a motion, if you will, on her plan A, if you want to sort of get, take a vote to get a sense of what's the recommendation that this committee would be providing to the full commission.
Maybe we'll have Jackie rephrase that after Amy. I see your hand.
You know what the hardest thing for me being on this commission, and particularly in this subcommittee, has been getting rid of the bias that I feel that, why should there be a pathway, a non-exam pathway? I had to take the test, therefore everyone else should have to suffer and take the test too, right? And that's been interesting, running the gamut of thought process for the last 4 or 5 months, being a part of this commission and part of this particular subcommittee, and dealing with that bias, because I think that there are going to be some of my colleagues out there, probably in the other subcommittee, that might have that same bias feeling too. And today's session really, for me, resonated the most out of all the sessions that we've had in terms of considering a non-exam pathway. So I feel that maybe in the next all commission meeting, we could have some words addressing that bias that maybe others are feeling and are not going to speak up and talk about it. This is Amy, and I'm done speaking.
Thank you, Amy. I appreciate it. Jackie, did you want, I know we're out of time, but did you want to sort of restate then what you might be proposing for a recommendation?
Yeah, I could certainly give it a try, and please, I take friendly amendments. The subcommittee proposed that the state of California develop a non-exam alternative or a non-exam pathway to licensure, that it begin at a set date in which the state bar and the Supreme Court, along with law schools, would develop a short-term bridge solution that would then lead to a more developed curriculum plus external assessment to ensure competency. It's a lot of words.
Can I clarify the intent is, or whether or not this includes, in addition to a non-exam alternative, an exam alternative as well, so that there would be two?
Well, and that's the same question, yeah.
Sorry.
Neil had the same question.
Oh, so because I was kind of thinking about it through Susan's lens of California graduates, because it allows you to actually work with California law schools on the type of curriculum that would then lead to the more sophisticated assessment for competency. I would keep an exam in place, whatever it might be, for out-of-state graduates of out-of-state law schools.
But what about California? Would there be an exam component in your motion for California? None at all. Okay.
None at all. That's where I started.
Dr. Henderson.
I guess one amendment that I would make to Jackie's motion is that the non-exam pathway demonstrate satisfy the pertinent psychometric requirements for validity and reliability, basis in the practice analysis, that whole suite of things.
that feels sane, not friendly, but sane. And so I will allow it to be added.
So Jackie, we haven't talked about it a lot, but to me, there ought to be an exam pathway, because some people just, maybe they don't want an experiential route. They just want to, they just want to take labor law classes and other stuff and oil and gas, and then they just want to be licensed. I mean, it's traditional, and it I think to answer the question that Susan asked a bit earlier, it would be a better segue for our bar group to continue what they're accustomed to seeing.
And I don't disagree. I think that the trouble that I have with that is that, and this is just on a personal level, and it's kind of the exact opposite of Amy. I don't think the bar exam establishes that someone is competent to practice law. I think it establishes a very limited set of things regarding their ability to take tests and memorize material and regurgitate in a timed manner. I get that it's got all kinds of psychometrics behind it, but if what we're talking about is protecting the public and making sure that our graduates are competent to practice law, then it seems if we set something up that would be the pathway. I get that it's easier to take, like to have that alternative one, but is it meeting the same criteria? Like, I don't know. I think it's a conversation that we need to have. We've accepted that the exam only is the way to determine competency. So now we're going to accept two different ways. I'm absolutely open to that, but
I think also, I'm sorry, the
yeah,
other component of it is what the other subcommittee is doing, which would, I think maybe you're thinking of it as the existing bar exam, which is, as you mentioned, problematic in certain ways, or it has been argued as problematic because it teaches rote memorization rather than what you actually do as an attorney. But if you combine a non-exam pathway with a potentially modified version of the bar examination, would that change your view?
Yeah, that's a good point, Justice. Thank you. Yeah, I would love to hear what they're talking about in the other subcommittee.
Can I just raise a quick point here, because this sort of goes back to Amy's comment. Sorry, Dr. Henderson. But just a quick thing is that another voice here is our actual bar within the state of California. And my concern about automatically saying, okay, we are now going into X year without having a bar exam, instead maybe having some sort of supervised practice program, which sounds great, but may impose a certain amount of hours requirement. That I don't want to create a scenario where basically a law firm in California is looking at a California candidate, and under this new program, there's no exam pathway, and that law firm has to wait for that applicant to finish maybe a year's worth of supervised practice, whereas they're looking at another bar candidate applying out of state who can only needs to spend potentially 300 hours to pass maybe a UBE. So just throwing that into the mix. I know, again, the bar exam has its own issues, right? But I'm also sort of expressing the fact that you've got a certain dynamic in hiring here as well.
Dr. Henderson.
I was just going to address the point that it is quite possible to design studies to assess the equivalence of rigor of a non-exam pathway with whatever bar exam component ends up being in place. It is possible to demonstrate that the two different assessments are equivalent in difficulty.
What would the challenges be in devising a law school curriculum if there was an option for the students to take an exam or to go through this alternative path? How would you prepare them for both of those things? Susan?
I would just start by saying, without knowing the details, it's very hard to answer that question with a straight, you would do it this way. Or my initial reservation is, I'm not sure you can do it. And that's why I think Jackie's proposal of sort of starting us out of the box of saying, look, don't put an exam alternative, at least as the sort of maybe ideal, say the non-exam path should be the path. And then if we have to add an exam path or the other committee is doing work that we don't know about, those are valuable additions. But I think that if you're talking about something like taking a curriculum that exists now where students are getting all the basics and adding to the experiential component that is required, adding some supervision, some rigor requirements, and things like that, which are basically an enhancement of existing practices and programs, that we can have a divergent path where students can elect to take an exam or elect the experiential option. But if we are talking about a wholesale change in law school curriculum, that is the kind of thing that we cannot do both simultaneously.
Amy?
You're definitely going to need the buy-in of the deans and the law schools, because they're the ones implementing this pathway, this non-exam pathway. And my second thought is, if the state of California decides to go on a non-exam pathway, what is the measure of its success? Are we going to see a reduction in complaints? Are we going to see a reduction or an increase in, like, what is the measure that this program is going to work, so that we know if after 5 years we're worse off, do we then consider going back to an exam process?
Well, I mean, clearly one answer to that question, it's not going to be the percentage of people who pass, right? It's going to be diversity, inclusion, access, providing services. That's the measure, right? It's not going to be, well, you know, here was the percentage in 1997, here was the percentage in 2017, and look at us now.
Okay, I understand that diversity and access is definitely going to be a measure, but at the ultimate, in my mind, the ultimate consideration is protecting the public. How do we measure the competency and the success of a non-exam pathway?
Amy, I think one place we could look is Wisconsin with diploma privilege. And if you look at the kind of statistics out of their state bar regarding disciplinary actions for those who entered through diploma privilege versus those who took the exam, because any out-of-state person needs to take the exam. They have the studies on this. There is no distinction between the two in terms of diploma privilege leads to more disciplinary actions because they didn't have the bar exam. So I think there are states that have alternative pathways. The Daniel Webster program we could look at in New Hampshire to see how they're measuring the success of their program as well. So there are places that we can look to see what alternatives to a bar exam have done in terms of their success metrics. So I think it's a good question. I think disciplinary action is one of those things that we could look at. And if you look at the Wisconsin statistics, most of their disciplinary actions are on not kind of substantive knowledge or skills, but the things that come up, the issues regarding client contact and whether or not they're following through and whether or not they met deadlines and whether or not they have any kind of mental health or other substance issues that might be influencing their ability to practice, which isn't really about the exam itself, but other issues going on in their life. So I think it's important for us to identify the metric. And I think we have some places where we can look to find where we might do that.
Do you think malpractice carriers would be able to divulge vague metrics as to the amount of claims that are filed by against non-exam or non-traditional exam attorneys?
It would probably it would be problematic because I do a lot of resolutions where everything's confidential. So, but you're talking about just general numbers. I
Yeah.
think it would have to be part of their licensure within the state. Otherwise, they would not want to disclose that information, I would think.
Well, and I'm not, right, so you're not required to have malpractice insurance. So I don't even know that we have the count, right? So how many people have it. So it might be a difficult, sort of looking over time may not tell us much if we don't really know, if that's not really representative of all of the attorneys out there that are practicing.
Just to add one other issue with malpractice that I used to teach in ethics is one of the biggest problems with malpractice is that it's negligence-based, not ethics rule-based, and an awful lot of misconduct and discipline is related to ethics violations that are not malpractice.
Mm-hmm.
So is the recommendation from today to develop a non-exam pathway with a short-term bridge pilot and then looking toward a longer-term permanent pathway?
Just to clarify, I'm not sure that we want to call it a short-term pilot. I think we want to call it a short-term bridge.
Okay.
A pilot suggests that we're going to do something separate and then start long-term. And I think we have more of a transition in mind, that we do something now with a goal toward a longer term, more consistent and subject to all the psychometric verification that we would like for a long range program, but that we provide some sort of short-term bridge. And that more importantly, the Band-Aid pulls off now. There is an alternative to the California bar exam and we lead.
Okay, so the recommendation is that we develop a non-exam pathway with a short-term bridge transition program while developing a longer-term program.
Semantics aside, I would agree with that statement.
With psychometric components built in.
With pertinent psychometric requirements on validity and reliability built in. I took some notes. I've got a pen. Is that consensus?
Well, so Jackie, is that a good summary of your motion?
Yeah, I also heard, and we talked about leaving the exam in place for those, but I know I didn't want to assume that we had taken that off the table. I think we spoke about it, but didn't say it or not. So I just want to leave that open. That is consistent with what I proposed with the amendment by Dr. Henderson.
Recommending developing a non-exam pathway does not at this point mean that there won't also be an exam.
Well, so I'm sorry. So, but Jackie, your recommendation was that is the exclusive pathway for California law school students.
That's what I originally offered, but then other people brought up the need to maintain it. And we had some conversation about what that would mean for curriculum and law schools, et cetera. And I don't know that that got resolved. So I wanted to make sure that it was understood what we were recommending. Only the non-exam pathway or both, because I wasn't sure where we left.
I'm not sure there's consensus on only the non-exam pathway for California law school students.
Right, that's why I was thinking we'll take sort of Jackie's motion as intended, as amended by Jim Henderson, to see where the vote is on that. If the vote, right, because her approach was that's the exclusive pathway for California law students.
Okay, and I thought the recommendation was to be not exclusive, but we can. Yes, Josh, sorry.
I'm a little confused. Was that even the question of this subcommittee on exclusivity?
It is one of the questions, yes. The second page of the second screen of the subcommittee guiding questions that were presented to you included our recommendations mutually exclusive of the other pathway.
And that's for both subcommittees had that question?
Yeah.
Thanks.
So I'm clear, Jackie's motion is to have the non-exam pathway as the sole pathway for California law students.
As a starting point.
Just to be able to take a vote, and then we can figure out if that's not the way that the committee is leaning. The committee wants to make it one of two options for California law students, then, right, just putting something out there to vote will help us narrow in on that.
Can I ask my question again a slightly different way? Because you're about to call the vote, right? Are we supposed to vote our conscience, or are we supposed to vote thinking what is likely to ultimately happen? Because those are two different votes, as you can probably guess for me. If we say it's exclusive, yes, that's my conscience, but I don't think we're going to get anywhere with that. So I'm going to vote no on that and hope that you then call the next vote. Is that what's going to happen? Is that the sequence?
It's my expectation.
Yeah, so if Jackie's motion fails, then we would ask if there's another motion on the table. The second motion would be Jackie's motion, except it's not exclusive. If I'm hearing you all correctly about what that second motion would be.
Okay. Yes, Susan?
So just to confirm, it is your expectation that we vote our conscience despite its lack of practicality, even though we may ultimately have to include things, including an exam?
I don't think that's, no, right? That's not what we're doing. We're trying to figure out the best path forward for California.
Okay, so we just vote our conscience best path, even if we think best path is not ultimately successful.
No, I think I'm saying the opposite. I think we vote what we think ought to. I understand this. I think our charge is to try to move California forward, right? And you have to be pragmatic about it. You can't just go, well, I just think there should be no bar exam. I agree that ultimately, right, in my conscience, that's probably the right result, but that's not going to carry the day with our state bar, or even with this, with our other subcommittee that's working diligently on fixing the bar exam. We could have done this the first day, but I think we ought to be voting on the right path forward, whatever that is. For now, whether it's temporary. We could have a dual system of bar exam and alternate pathway for 10 years, and then people would lose interest in the bar exam or not, right?
There's so many ways that this could be put into practice. Do we know if we say, yes, we want to see a non-exam pathway moving forward? What is the next step after that, Justice? Is this group in charge of seeing that through, or is that another group that takes our results and puts this into motion?
I think what would be most helpful now is to try to come up with some recommendation to make to the larger group. And then perhaps we can discuss at that next meeting what our future meetings would look like, because we might have some helpful information or thoughts from members on the other subcommittee on the issues that we're discussing now. And so I think if we could take a vote on the two alternatives that have been presented, and then present those to the larger the larger committee, and then discuss what the next steps would be at that next meeting.
Audrey, could you read both proposals again that we're voting on?
So to develop a non-exam pathway for California law schools that will be the sole pathway to licensure in two parts: a short-term bridge transition program and a long-term program with the pertinent psychometric requirements for validity and reliability built in.
And then the second vote would be
to take out the part where it's the sole pathway.
This is Amy. I'd be inclined to vote on the second one.
Okay. Well, procedurally, maybe we should vote them one at a time. So Kim, maybe you can help me with this one. So I will read the first one again. So to develop a non-exam pathway that is the sole pathway for California Law School graduates to licensure, short-term bridge transition program, along with a long-term non-exam pathway program with the pertinent psychometric requirements of validity and reliability also built in.
Susan Bakshin,
No.
Jackie Gardina,
Yes, awkwardly.
I think Kim froze. She'll be right.
No.
Audrey, you want to call roll?
Yeah, I was like, I could probably finish with a few people.
Can you hear me?
Kim,
Yeah,
sorry.
Kim's
I
fine.
apologize. I apologize. My internet has issues. So Dr. Henderson,
No.
Judge Reiser,
No.
Judge Rosie, Mylene Spencer,
No.
Amy.
She freeze again.
Yeah, Amy, I think that's you.
Yeah, my vote is no. My vote is no, Kim.
Thank you. The motion did not pass.
Okay, so now we're voting without sole pathway. So to develop a non-exam pathway, a short-term bridge transition program, and a long-term non-exam pathway program with the pertinent psychometric requirements for validity and reliability built in.
Susan Bakshin,
Yes.
Jackie Gardina,
Yes.
James Henderson,
Yes.
Judge Reiser,
Yes.
Mylene,
Yes.
and Amy.
Yes.
All right, motion carries. We have a recommendation for the next meeting of the Blue Ribbon Commission as a whole.
Okay, thank you very much for everybody staying on a little longer too, and for all the presenters here today, as well as the members of the public who have commented and participated. Is there any other business for today's subcommittee meeting? Okay, hearing none, the subcommittee meeting is adjourned, and our next larger commission meeting is, I believe, March 2nd. Is that right?
yes, that's correct.
Okay, thank you. We'll see you then.
Thank you all so much. Thank you for staying on late. Thank you.
Thank you.
Thank you.
Thank you.
Thank you.